Is there any urgency that Friday?
Regarding pension.
Pension, some 19 of Wednesday.
I beg to mention item 42. On the consent of the other side, I need the matter.
42.
42, madam.
42 and 41, they're connected. 41 and 42 are connected.
Yes, my lord, already consent was taken.
For both the matters.
Yes, my lord.
Petitioner is the same.
Same.
Maybe same. Have you informed him they are connected? 41, 42 on the request of the counsel for the respondent, matter stands deferred instead after 1 week. It is submitted that consent of the counsel petitioner has been obtained. List after 1 week.
Next witness.
No, after 1 week. Yeah.
May I please beg to mention some listing for admission. Any date?
Admission 24th. Obviously. 24th. Huh?
After 24th or before 20, I have another appointment in.
All right, 21st.
Item number 35. Please give another date after 3 weeks.
Item 35. On you are for the petitioner. You are for the petitioner.
Concern petition for it.
Item 34.
35.
35. Okay. Item 35 on the request of your name?
Narayan Chandra Uja.
Okay. N.C. Uja, Learned Counsel. Petitioner stands deferred to be listed after 3 weeks. After 3 weeks.
Thank you.
Wait, Lordship, I beg to mention item number 45, Lordship. We
45.
file affidavit in reply. We have taken already consent from the respondent.
45 on the request of the counsel for the petitioner stands deferred, permitting him to file affidavit in reply, released after 2 weeks.
A date may kindly be fixed, Lordship.
No. After you file it and make a mention. You're for the petitioner.
Yes.
Why is it compliant?
No, my lord, the petitioner filed. We are going to file.
It is submitted by the counsel for the petitioner that the petitioner expired during the pendency of the contempt proceedings. And the counsel submits he'd like to take steps for substitution. He prays for 2 weeks' time. Prayer made is allowed. He starts at 2 weeks.
May it please, Your Lordship. Your Lordship, with the consent of the other side, I beg to mention item number 29.
29.
Yes, I am appearing for the applicant in this matter, Your Lordship. We are newly engaged in this matter. We are awaiting some instructions. I not make.
You are newly engaged.
Yes.
Final line for the respondent. Sole respondent.
Your name?
A does.
Mr. A. Das, Learned Counsel. Your name appears in the cause list.
Yes, ma'am. Some accommodation.
A.
My lord,
Das, counsel for the petitioner submits that like to meet his instructions in the matter. Therefore, prays for 2 weeks' time. Mr.
B. Hazarika.
B. Hazarika appears for the respondent, does not object to the prayer. Released after 2 weeks.
Public.
For admission on Thursday, madam. So they are students of the Homeopathy College and they have completed their internship. Now they have not been issued with their final registration certificate, madam. For that purpose, they are unable to appear in the job opportunities. One opportunity is coming up on next week. That's why I'm praying for Thursday. Don't take up your options much time. The pleadings are also.
So for what? For final hearing?
Yes.
Final
I'll take
hearing.
5 minutes of argument.
Final hearing. When was it last listed?
It was last listed on June 15th.
For orders maybe, but not for, we don't know whether the matter is ready for final hearing.
Well, the pleadings are complete.
Maybe.
Well, I'll be pressing for a final disposal.
So then we'll issue rule and we'll list it tomorrow. You want it tomorrow?
I can take a chance.
Tomorrow.
I'm praying for Thursday, madam.
Thursday, all right. Thursday.
Okay.
Release this matter on this item on Thursday, 13th.
No, my lord, I'm Mr. Madam. It's a pending repetition. I'm praying for listing for admission on Thursday.
That's right.
Thursday is 13th.
13th.
Yes.
You said listed on 13 for admission. Why are you praying for unlisted?
I thought your lordship was referring to the list.
I beg to mention item number 4. Kindly.
You're for the petitioner.
Yes.
Item 4 on the request to stand paper to Mr. Ram. Which?
May I please? Back to me.
What?
Promotion on Wednesday.
Is it filed?
Yes, yes.
Obliged.
May it please your lordship, I beg to mention listing of arbitration petition case number 47 of 2026, your lordship. May it be listed on any day.
When is it?
Much pleasure, your lordship.
Beg to mention for order.
Orders. 17?
Respect to item number 2,
Hmm.
I'll require to file an affidavit in opposition. Because with respect to the first item, we've already filed.
Notice has not been issued yet.
Yes, my lord.
Why?
No, my lord, what happened in this case, my lord? This is a case of compulsory appointment, my lord. I filed one case in the year 2024. Then they have filed one affidavit showing that my name has been cancelled in the year 2016. Then I have to challenge this order. Again, I have filed this case. So, lordship, item 2 can your lordship can close this matter because I have come that
Item 2 was seeking a direction to consider your case.
yes,
And item 1 is where your case was rejected.
rejected. That is
So
why.
item 2 become infractuous according to
Infractious, yes,
So
madam.
it's the other way around. Item number 1 was the earlier written.
24, madam. Item 1 negative or 6183 2024 lawsuit can be closed the matter.
If we have to rely on your submissions, we'd have closed item 2.
I'm sorry.
SK Devi, Learned Counsel,
19.
Commissioner, and Mr. Riyak, appearing for you are for BTC.
Yes.
The challenge made in the writ petition is for a direction the respondents to consider to appoint the petitioner on compassionate ground. While challenge was while the said proceeding was pending, case of the petitioner was considered and rejected, which came to be challenged by a subsequent writ petition being WPC 2902 of 2025. That view of the matter, the counsel for the petitioner submits that the WPC 6183 of 2024 same may be closed. Stop submissions are not objected to by the counsel for the respondents. Accordingly, WPC 6183 2024 stands closed as infractuous interim order. If any stand vacated, pending IAs are also dismissed. And Mr. Ayatria for BTC, MSK Fukun for respondent 5 and 6. So far as item 2 is concerned, standing counsel BTC prays for 3 weeks time to file their affidavits, considering the issues involved, let notice issue, returnable forms. Since the respondents are represented, Atria for Boroland, MS A Fukan for respondents 5 and 6. If the respondents are represented, notices are waived. Extra copies be furnished within a period of 1 week from.
What's if date may be fixed?
Let them file their affidavit.
Oh,
You
that's
may like to file a reply,
Yes.
then you fix a date. Where is the order?
Order lordship to find at page 14, relevant page 26.
Third, counsel for parties issue notice. Whenever forward. Alleging willful disobedience. Steps on the respondent by speed force. Based after return.
Possible to make for pending, senior counsel is in there. Kindly-
Yes, who saw the respondent here? Any instructions here?
Here, your lordship, our impugn order will be same, your lordship, the order which were passed, your lordship. Although your lordship instruction available.
Instructions are awaited. Let it be on 19th, day after. The request made by the council.
My lord.
Yes.
Can I plead, my lord? My lord, the petitioner is an 8-year-old minor, my lord.
Yes, any instruction?
This is our surgery. She is appearing in this case for KBS. But she is on her way, so lordship. Also, she has informed me that she has not received any instruction, so they can come on Friday, lordship.
My lord,
But we can dispose of the matter.
my lord, if I may, my lord. My lord, actually, the person, my lord, my lord, the child, my lord, he's already missed 2 weeks of class, my lord. And assuming that 2 chapters are covered per subject in a week, my lord, he's already missed about 12 chapters as of now, my
Mr.
lord.
Counsel, you are not even admitted.
Yes, my lord.
We are considering your prayer,
Yes, my lord.
subject to instructions coming. Right? The question of you not being given admission is required to be examined. Examine it. This classes and you say that you are unable to catch up, then why should we even entertain the writ petition now? Midstream.
My lord, subject to the final orders, my lord, so that he
No,
doesn't-
final orders doesn't make any sense tomorrow upon interim orders, if the child is allowed to be admitted. Then supposing we disagree with your submissions, we want to reject the prayer, then he'll have to be taken out.
Even if he transfers somewhere else, at least he would have covered that portion.
It's
of the
only
syllabus.
Friday.
Friday.
Later, make an endeavor to have it on Wednesday, day after. Day after tomorrow. It is submitted.
Instruction has to come from Delhi, lordship. So,
Oh, Delhi is how many hours? By email.
lordship, we can see Friday.
Day after tomorrow, we are talking about an admission of a child.
16-year-old.
That's right.
But state government does not allow to appear in that case. 16 years. 8 years.
Minors.
And let it come on Wednesday.
Wednesday. On the request made by MS R. Bora, Learned CBC, matter be listed on Wednesday, which is on 13th. 12.
Yes. All right.
Yes, you got your instruction.
So nothing as yet till Friday.
Not Friday, let it be on Wednesday.
This day after tomorrow.
Yes.
But the problem is that the new education policy envisages that there can be only 40 students. So we are having to get our instructions from ONGC as well as from the headquarters. The child is a minor and there's a problem with the seating as well. Therefore, I was asking till Friday. I apologize, lordships. We are trying our level best, but another problem which the child will face is if we give him admission now, later on, if the child is not 16 plus at the age of metric, the child will not be allowed to sit in the exams. That is another difficulty which we're trying to work out.
So, the demands of the petitioner, the child whose father is that because of government service, he has to be transferred.
That's what it is. So, this is a transfer between ONGC to ONGC. And whether the new education policy permits in such schools, this is we call it I apologize for the word, they're called schools which are specific to certain organizations, like for example, the railway schools, or for example, the IIT schools, all Kendra Vidyalayas which are for a specific organization. Now, this school is for ONGC. Whether the new education policy permits ONGC to go over and above the 40 student ratio, which is the mandate of the policy.
So then the transfer order will have to be recalled.
Then
What
that
do
is-
you, what do you suppose that a student?
That is between ONGC,
minor-
Lordships. That is between ONGC.
That's
what I-
right.
Therefore, we are trying to get our instructions from everywhere, Lordship. That's why I was saying Friday. I apologize for the delay. They had not served a copy on me also, Lordship. I have got the copy from my learned friend.
Because you were not available, we had to request Mrs. Bora to
No,
come and appear in the matter. There was no standing counsel, we are told.
Because I was never served a copy of the petition, Your Lordships, before the petition was filed. And my name is
Let
still
it-
not
let it
reflected
be
in the
on-
cause list.
Let it be on Thursday.
Yes, Your Lordship.
Thursday.
I'll try my level best, Your Lordships.
List on Thursday, enabling MS R. Chaudhary to the council for KV, call it KVS,
KVS.
obtain the required instructions in the matter. MSR Bora appears for the union. Union is a party here,
Yes.
ONGC.
Union is party, Ministry of Education, not CBSC and not
And
ONGC.
have you arranged the ONGC as a party?
Oh my lord.
You have to,
I'll rectify the error.
school is run by ONGC.
It is run by ONGC. That is why we are trying to get our instructions from ONGC. We only run the, it's just that we established the school there, but the school is run by ONGC.
Is there a standing council for ONGC?
That time.
All right, let us see on Thursday
All right.
for motion.
Lordship, my name may kindly be reflected in the cost list.
Names of all standing council be reflected in the course.
If you're right.
Yes, Your Lordship, the petitioner, Your Lordship, whose services has been earlier provincialized.
We'll issue notice for today. What else? You are challenging the provincialization of the private school.
Yes, Your Lordship, that I have challenged, and also Your Lordship, probably Your Lordship, she is entitled, Your Lordship, but one aspect they did not consider, Your Lordship. That, Your Lordship, when more than 100 students are there, Your Lordship, there is an additional post they can provincialize it, and that under comes.
Mr. S. Botapur, senior counsel, assisted by Mr. So, counsel commissioner, and Mr. P.K. Bora here for the
1,
elementary
3 and 5.
respondents, 3 and
1, 2, 3 and 5.
1, 2, 3 and 5. MSK Pogan for respondent. Since the respondents, council represent the respondent 1, 2, 3, 4, 5 are represented, notices will be no common notices are required. The extra copies will be furnished within 1 week. Steps on 6 and 7 by speed post within 1 week.
And dusty service may be allowed, Your Lordship.
Service by way of dusty is also permitted, provided the same is did through the registry. And an affidavit of compliance is filed thereafter.
Deeply obliged.
Lordship, matter may be passed over for the time being, Lordship. Lordship, my senior, Mr. M. Swami, is takes in court number 2, Lordship.
Here we are paying for a receipt of notice only. We have to take instruction.
Lordship, my senior will kindly pass over for the time.
Timing.
Please, Your Lordship. Praying for notice at this moment. Yes, matter pertains.
What are you challenging?
Yes, Your Lordship. Lordship will kindly peruse the speaking order dated annexure 19, page 122. There, prior to this, Lordship will kindly take up page 121. What has happened? The first stage of litigation. This court allowed my representation to be considered. And by the operating parties at page 121, where Your Lordship, may I read it, Your Lordship? 121. View of the concern of the parties, the petition is disposed of. The direction to the Secretary to the Government of Assam, School Education Department to take a decision on the petitioner's representation dated so and so within a period of 3 months for the date of receipt of a certified copy of the order. We are praying for a deficit. We are asking these petitioners, this set of petitioners are asking to be placed before the deficit system of granting date when the college was brought in. By way of this speaking order was passed, which Your Lordship will find. The findings, the first part, they rightly record the thing, but when they give the decision, they subsequently say that we are not eligible. The findings, Your Lordship, kindly fail. It appears that the petitioners were appointed as postgraduate teachers, lecturers in various subjects in Dio Morna Senior Secondary School, located at Durham District,
Despite being similarly situated with other junior colleges who had been brought under the deficit system of granting aid, the
We
petition.
issue notice.
Yes,
right?
yes.
Council.
Yes.
One and three, Lordship.
1 and 3. And steps on
Yes,
here
yes.
to respond. The respondent, the representative, step of furnished
Okay.
to 1 week. PM monitor for
I'm okay.
Lordship. Here my grievance is, Lordship, I was accommodated as tutor assistant professor, but order dated, Lordship, 5th February 2021. Lordship. My contention is that I ought to have been accommodated as assistant professor, Lordship. I have the necessary qualification. Lordship, the provincialization order, Lordship, will find at page 19. CL number 12. At this stage, Lordship, notice maybe. I have the necessary.
Council for party. Status. Mia appears for respondent number 1, 3, 4. Paper notices in respect of respondent 1 to 4 stand waived. However, extra copies be furnished within a period of 1 week. Steps of respondent 5 by speed post within 1 week. That will be listed after the return of the.
Lordship.
May I please, Lordship? Lordship, in this case, Lordship, petitioner husband was retired on 31/7/2013, Lordship. And thereafter he was died, Lordship, in the year 2016, Lordship. And Lordship, though Lordship, provisional family pension was granted in favor of the petitioner, Lordship, but later on, Lordship, it was discontinued, Lordship. And an impugn order was issued, Lordship, in this regard, Lordship, as page 32, Lordship, for excess travel, Lordship. During his service tenure, Lordship, he was deprived of 3 months.
NSP Das, for respondents. Secondary. Elementary. Who's for elementary? Who's for elementary? MSN Fukan appears for elementary education, representing respondents 1, 2, 4, 5, 6. MSK Fukan for respondent number 3. Respondents being represented by respective council, standing council, notices of waive. Extra copies be furnished within a period of 1 week. Released after the returnable.
Lordship, family mention may be in the meantime, Lordship, granted from September, Lordship.
Pendency of the petition will not be a bar for release of family pension if otherwise admissible by the respondent. Otherwise eligible. Yes,
May I please? This matter is pertaining to compassionate department.
but this is in Arunachal,
No,
right? No, there's some order of retaping here. Is it the same matter? No.
that is my, you don't understand. This matter already dismissed.
Huh?
Already dismissed by order dated 28/1/26, my lord.
WPC 336
Yes, my lord.
of 26. Shall it dismissed?
Yes, my lord.
Then this writ petition filed by the petitioner, Deputy Decca, is numbered as WPC 336 of 26. Is it 26 or 25?
Actually, it was filed on 25.
25.
Was registered on 26, madam. That's all.
26, which came to be dismissed by order dated 28/1/2026 by an order passed by court. Stop. Registry has placed copy of an order passed in writ appeal 266 of 2026, which appears to be an order passed by the division bench of this court, which arose out of an order by which the order by which a direction was issued for the matter for the writ petition being WPC 336 of 2026 be posted for listing before the single judge on 10/8/2026. Stop. The appeal was disposed of until the time the matter is listed before the single judge for final adjudication. The appellant therein directed that the appellant shall not be insisted upon in the place of posting. Stop. There. The order passed in writ appeal 266 of 26 was passed in an appeal preferred by one Dom Taku, NOM TAKU, the resident of the district of Upper Siang in state of West Bengal, and the respondents of the state of West Bengal and the education. Whereas WPC 336 of 26 filed by one Deputy Dega, the state of Assam, the respondent. So, registry, it therefore appears that the direction in the writ appeal by the order dated 3/8/2026 passed in writ appeal 266 of 26 perhaps does not pertain to the writ petition which is listed before the court being WPC 336 of 2026, as the said writ petition has already been dismissed by the order dated 28/1/2026. So, registry to verify the same and thereafter have the matter listed. The registry will verify the same and place a report. Matter be brought to the notice of registrar judicial. Number get I gave. There's something wrong.
May I please, your lordship? My lord, here is this petition, my lord. We are challenging a transfer order, my lord. My lord may be pleased to find the order is at page 21, annexure 2. My lord may be pleased to take up. My lord reflects that in the greater interest of the public service, the following contractual assistant teachers working as so and so is hereby transferred and posted as below. Now, my lord, I am the serial number 2. Now, my lord, the main ground of challenge is that, my lord, though it had been shown in the interest of public service, but, my lord, this transfer is in violation of the, my lord, the Right to Free and Compulsory Education Act of 2009. it will, my lord, affect the entire, my lord, the pupil teacher ratio of the present school wherein, my lord, the present petitioner is working. For that, my lord, I beg to draw my lordship's attention to page 29, annexure 6, my lord. This is the present school, my lord, from where I had been transferred. And my lord may be pleased to find the number of total students is, my lord, 104. And, my lord, the total teaching staff is 3 before my transfer, my lord. Now, after the transfer, my lord, it will come down to 2. So, my lord, the pupil teacher ratio as per, my lord, section 25 of the Right to Free and Compulsory Education Act 2009 is directly in conflict. Now, my lord, the school wherein I had been transferred, my lord, may kindly turn to page number 30, my lord.
Somebody may be transferred in your place.
No, it had not been done, my lord. And secondly, my lord, this is purely in a my lord, political my lord, it is, if my lord may be pleased to call for the record, my lord, it will reflect the entire issue, my lord. What has happened, my lord, my brother, who is a, my lord, active political worker for, my lord, a particular political party, and he worked for, my lord, that party during the last, my lord, ensuing assembly election, my lord. As a result, my lord, there is the MLA and the one powerful minister, my lord, have written for the purpose of transfer of those persons, my lord, who are not supporting the present ruling government. That basing on those allegations, my lord, those statements, these transfers had been effected by sacrificing the fate of the students, my lord. Primarily, my lord, this is in conflict. My lord, may kindly turn to page 30, my lord, once, my lord. And in here, my lord, may be pleased to find the total teaching staff is, my lord, 3, and number of students was 70 before my transfer. Now, my lord, 3 plus 1 will be 4, and students is 70, my lord. So it will, my lord, is in
No,
conflict.
this page number 30
my lord,
is
the school,
which school?
the school wherein, my lord, I had been transferred.
You have been transferred.
Yes, my lord.
And what is the ratio to be maintained?
My lord, 25:1, my lord, in this category, as per the RTE.
And what about your school?
My school, my lord, is at page number 29. Already there are shortage of teacher, my lord. 3 out of 104, my lord. If we come down, my lord, it minimum 3 teacher is required, my lord. 25:3 is equal to 75 students. 4 teacher is the requirement, my lord.
You will get instructions,
My
Mr.
lord.
Yes, I'll get the instruction.
When can you get it?
After 10 days.
After 10 days. Heard Mr. Ear. PL and a senior counsel assisted by N. Loscott. Learned counsel with petitioners, Mr. S. Bora. Standing counsel, SSA. APS for all. 1 to 6.
Man.
No, not all, my lord. 3, 4, 5.
3, 4, 5.
6.
3, 4, 5, 6. MSN Fugan, APS for
One.
respondent 1 and 2. Petitioner is agreed by the impugned transfer order dated 23/7/2026, whereby the petitioner has been transferred from
my lord,
Tekera Mari Chor,
man. Bamun.
Banmuri
Banmuri
LP. Stop. According to the petitioner, this is in violation of the right of children to free and compulsory education Act 2009, more particularly section 25, in as much as the pupil teacher ratio has been violated. Stop. In the school where the petitioner is presently working, dashboard available in the portal reflects the total students of 104 with the total teaching staff of 3, which reflects that the PTR ratio of 1:25 is mandated under section 25 of the Act of 2009 has not been maintained. There is a shortfall of teachers. Now, if the petitioner is transferred out, where is the dashboard for the school which the petitioner has been transferred, shows that the total students of 70 with a teaching staff of 3, and if the petitioner is transferred, he will add increase the number of teachers, which is beyond the ratio required to be maintained. Whereas the school in which the petitioner is serving, there is already a shortage of teachers. Being agreed, the present writ petition is filed. There are Mr. Bora, we obtain instructions in the matter. He prays for
10 days, immediately after.
submits that the matter be listed immediately after 10 days. Accordingly, that the petition be listed again on 21st. 21st. Till the next date of listing, no coercive action initiated against the petition on the basis of the transfer order.
Obla, declare.
You serve extra copies.
Please, sir. Pending at the way.
Yes, Mr. Goswami.
Lordship, there are 78 petitioners before your Lordship today. Now, they are all seeking provincialization as music teachers. Now, Lordship will kindly see the prayer, which is at page 42 of the writ petition. Just place it. A declaration to the effect that the impugn action of the respondents in restricting the benefit of provincialization of services to only 66 music teachers out of the list of 214 music teachers that contain the names of petitioners as well, violative of Article 14. Number 2, a writ in the nature of mandamus or any other appropriate writ, order, or direction of a like nature be issued directing the respondents to provincialize the services of the petitioners as music teachers under the Assam Education Provincialization of Services Act 2011 with effect from 1/1/2013 with all consequential benefits, including those retired from the list of 214 music teachers, as has been done in respect of 66 music teachers by notification dated so and so, dated 24/7/2020. Now, essentially, the fact is this, Lordships. Lordships will recall that 2017 Act, which succeeded this Act, came to be challenged before this court. Before this court. This Act of 2017, which succeeded the 2011 Act after it was repealed, I mean, it was held to be unconstitutional by this court, came to be challenged in a batch of petitions here. The division bench rendered a judgment in respect of the constitutional validity of the Act and also in respect of certain other aspects. But as qua music teachers, though the division bench held everything in favor of the music teachers, including holding that they have attained the right of government employees.
Para 104.
Lordship is right, but this para 116.
116.
But finally did not issue a mandamus against which some of us went up to the Supreme Court. Now, Supreme Court has endorsed those findings, who are the music teachers, in its own judgment, and has finally issued a mandamus with respect to the 214 list. But however, the government has now restricted to 66. So we are saying that the entire list, and the Supreme Court has very categorically noted in its judgment, I'll show that paragraph, that they have not disputed that list of 214. So all that we pray is what has been extended to the remaining 66, since we are in the same list, the same benefit be extended to us. That
has it been denied so far? Has it been denied now after the Supreme Court judgment?
Yeah, because they've issued an order only restricting to 66 people. That is the impugned order. That is the impugned order. So therefore, Lordship, they can take instruction on that.
And there are another batch of cases that are going to be listed on 14 days for Honorable Supreme Court regarding the same.
No, music teacher is closed.
So
I am only restricted.
Let us verify this. Then I will get
I am appearing in Supreme Court for my friends, but the music teacher issue is finished. The final judgment has been passed. So these are only music teachers.
So the direction is to be regularized.
Provincialized. If Lordship will kindly see para 116, if Lordship will kindly see para 116 of the division bench judgment, which is at page 112 of the writ petition. The division bench judgment of this court at page 112. May I just place it? Yes. From the record available before this court, we find that a number of venture education institutions and or teaching and non-teaching staff serving under them had in reality attained the requisite eligibility for their services to be provincialized under the Act of 2011. Now, next.
In some cases, that is specific as reference 214 music teachers, we find that even the district scrutiny committee constituted under section 10 of the 2011 Act of 2011 had verified their credentials, whereafter recommendations were also made on 6/6/2016 in favor of provincialization of their services. Pursuant to such recommendation, these teachers had acquired the status of government employees under the Act of 2011 for all practical purposes, with only the issuance of formal orders of provincialization of the services remaining pending with the government. Therefore, we are of the opinion that a valuable right had undoubtedly accrued in favor of those eligible teachers, music teachers, for issuance of formal order of provincialization of their services under the Act of 2011. Notwithstanding the same, their services were not provincialized apparently due to repealing of the Act of 2011. So this is a categorical finding in respect of 214 teachers, which has not been assailed by them. Now, Lordship will see how the Supreme Court.
we have filed a review against this order.
That is, Lordship now will
Review
kindly.
against which order?
Against this order of this honorable division bench.
But that Supreme Court has already closed it.
Closed it, Lordship, by finding a
Before this honorable court.
Huh?
Before this.
This order
in
will be
moral
subsumed into the order of the judgment of the Supreme Court.
Yes, Lordship.
and review is pending before, and it is fixed on 8/9.
Oh, Mr.
Now, Lordship will come to the Supreme Court judgment at page 266 of this writ petition, Lordships. Page 266 of the Supreme Court judgment. They just place it.
Yes.
Decision. Having considered a matter in length, we find substance in the contention put forward by the learned senior counsel for the appellants. It would be useful to reproduce para 116, 118, 114, 144 and 194 of the impugned judgment, which reads as under. I have already had para 116, which is relevant for us. Now, Lordship will just skip that portion and then kindly come to para 14 at page 268. From the above passages, the relevant issues for determination, both factual as well as legal, have in fact been duly considered in extenso by the High Court based upon material available on record and the official communications of the respondent state, which have not been controverted. We endorse the above returned findings of the High Court. So therefore, the High Court, now it is the order of the Supreme Court. And then Lordship will kindly see, if Lordship will come to the next page, para 260, page 269, I will just place one paragraph. I'll place two paragraphs, para 19 and 20, Lordships. Is Lordship at page 269?
Yes.
Be it noted, the categorical findings recorded in the impugned judgment quoted herein above have not been challenged by the state authorities, and hence the state respondents have accepted the same. Moreover, nothing contrary has been brought on record to indicate that at any point of time there was any controversy dispute with regard to the veracity of the list of 214 persons taken note of in the impugned judgment. And finally, Lordships, is the relief where they issue a mandamus. That is our case. So these people are in that 214 list.
Mr. M. Swami, assisted by S. Patwari. Mr. S.M.D. Chisti appears for Secondary Education Department.
Yes, so now 4, 5. Now, who is the additional seat secretary will be gone?
4, 5, 6, and 8. And an escape of one for respondent number 1, 2. 7.
Yes.
MS Borwa for respondent 3. So the respondents are duly represented by the respective counsel. Notices are waived, extra copies will be furnished in a period of 1 week. Petitioners are agreed by which order?
Lordship, this order is at page 272, Annexure 16, order dated 24/7/2016, 26, which is at page 275. The order starts at page 275.
Petitioners are agreed by the order dated
24/7/2026.
you are not aggrieved by this order, you want an
Well, we
order,
want a similar
order.
Yes.
Petitioners are agreed that in the order dated 24/7/2026 issued by the Director of Secondary Education, whereby the services of 66 music teachers were provincialized, respective high schools in different districts, with effect from 1/1/2013. Names of the petitioners who are similarly situated have not been included. The petitioners had appeared before the court, High Court, earlier.
Some of them
Not
have,
all lordships.
some of them we have given the table lordships.
Some of the petitioners had approached this court earlier, seeking a mandamus for the respondents to regularize their services. This matter ultimately came to be decided WPC 6094,
The first lead case is Mohor Ali Sheikh.
page number
That is page 71, lordships.
70.
The lead case is WPC 2729.
Where the division bench of this court decided several batch of writ petitions, where the lead case is WPC 2729 of 2019 or Ali Sheikh and others. So this writ petition came to be disposed of, accepting contentions made on behalf of petitioners. However, no mandamus was issued to the respondents for regularization of the respect of the claims raised by the writ petitioners.
That's para 190.
Petitioners carried the judgment to the Supreme Court, and the matter was ultimately disposed of. By which order?
Lordship, that order is at page annexure 15, page 259. Judgment of the
In
Supreme
Civil Appeal 13802 of 2025
and connected appeals.
and connected appeals, wherein the apex court allowed the appeal and directed the respondent authorities to But what was your prayer for?
That prayer for his lordship's extracted here. Is at page para 17. Para 17, lordships, at page 268. Great in the nature of manner. Similar.
Whereby the prayer made by the appellant for the apex court was seeking a writ in the nature of mandamus. The respondent authorities to provincialize their services with all financial benefits, including those retired after the recommendations made by the respondents were initially recommended or considered eligible for provincialization, but were not provincialized in spite of having served in the school for a considerable period of time, stood allowed. Stop. Thereafter, it is in deference to the directions issued by the apex court that by order dated 24/7/2026, names of 66 music teachers, as reflected in the said order, were provincialized
Out of the list of 240.
in the respective high schools under different districts. Stop. According to the writ petitioner, these names were a part of the list of 214.
Dated
Music-
6/6/2016.
Dated
6/6/2016.
6/6/2016, which wherein the names of the writ petitioners were also included. It is therefore submitted that similar orders be passed provincializing the services of the writ petitioners. But having heard counsel for the party, we should turn it over. Respond to the representative. Formal notices be issued, however, extra copy furnished within a period of 1 week from today. The respondents will file their counter.
Yes.
before the next stage of listing. Relist again after 4 weeks.
It's so convenient, can it be 21st September? Convenient.
21st is a holiday. So you may have it on the 23rd. 23rd?
Yes.
When is this matter on 23rd of September?
Great, very good.
Is your lunch?
Yes. Yes, yes.
Getting maybe completed even, that's it.
Huh?
Matter may be fixed for the hearing.
Who has filed affidavit? Who has filed affidavit?
Respondent number 2 is filed.
Who's respondent who?
Respondent number 2 is the Secretary Board of Secondary Education. I will find the reply.
These school particulars were not submitted. Then you are praying for correction of date of birth.
Yes.
Then how will it be corrected? How will it be corrected?
But 4 and 5 had not submitted their.
So CD is the party.
Heard the petitioner before the court prays for correction of his date of birth. Notice in the matter was issued. On 4/12/2017, the respondent number 2, namely the Secretary, Board of Secondary Education, filed their affidavit. Wherein there is a categorical stand that on the application filed by the petitioner for correction, school admission register was required to be submitted. Board of Secondary Education issued a communication to the head of the institution of the respondent number 4 to submit the school admission register within 6 months in order that the claim of the writ petitioner can be entertained and necessary orders may be passed for correction of the date of birth. So this was not received by the board. And therefore, there was no correction effected in the date of birth of the petitioner as per his prayer. So, the office notes, the Lozima Court order dated 15/7/25 reflects that AD card in respect of 4 and 5 has been served, and therefore service is deemed to be completed. However, none represents respondent 4 and 5. So, perusal of the affidavit filed with the board reflects that the school admission register of the concerned schools would be necessary to examine the claims of the petitioner for correction of his date of birth. So, therefore, permit the petitioner take dusty service on respondent 4 and 5 within 1 week from today, subject to the notice being noted through the registry of the court and an affidavit of compliance being filed thereafter. Release this matter again after 4 weeks. You take dusty service on 4 and 5.
Bless you.
MSP does it for the respondent.
Today it is fixed for my lord compliance, submission of compliance. Lordship may kindly look into the order dated 25/6/26. Last one.
Is for the respondent. Okay.
And take it after some time. Deem size is appropriate appearing.
D. Mushari.
Yes, Lordship.
By the order dated 25/6/2026, the registry was directed to place this matter today, on which date the respondents were directed to place before the court a compliance report. So, said order, although reflects the name of the counsel for the petitioner, does not indicate whether the counsel for the respondent was present and or that the order was passed in the presence of the respondents. So, when the matter is called up today, none represents the respondents. Mr. S.M.T. Chisti, learned counsel representing the Education Department, submits that the matter was represented earlier by Ms. D. Mushari, who was the counsel representing the respondents. Stockholm. Therefore, the registry is directed to communicate a copy of this order to the standing counsel, to senior standing counsel / standing counsel, PTC, so that the directions contained in the order dated 25/6/2026 can be complied with. Release this matter again on 26th of August.
Order dated 27 February, some direction is there to take fresh steps, Lordship.
Hmm.
We'll take it, Lordship. Some inadvertence we can take it.
Counsel for the petitioner prays for any granted 4 weeks time to take steps.
Absolutely.
Released after 4 weeks.
Matter
Yes.
is otherwise ready for hearing, madam. Sitting is already.
What is to be heard here? What is the matter?
Matter is regarding the termination of the petitioner from service. So matter will be fixed. After
It
we
is
got-
submitted that the petitioner is agreed by the termination order issued by the responding authority. Meetings are exchanged. The rules for the respondent. Do we have the records? The course list reflects TCR. Records are sitting.
My lord, earlier it was
Perhaps have come, Lordship.
it was before the education tribunal, madam.
Tribunal records is not.
It is reflected with TCR.
This is against the order of tribunal.
Or
You are
tribunal.
challenging the tribunal order.
Tribunal.
By the order passed by the Education Tribunal or PETA, whereby the claims of the petitioners are rejected, being agreed, the present petition is filed. Tribunal records have been called for. Is this matter, the issue room, matter be listed for hearing in month of September. September.
Public.
The benefit are we not use time to file it. That one is not.
3 weeks time. Yes.
2 weeks maybe given already.
Mr. P.P. Doctor, counsel for the
Standing council and secondary.
Standing Council Secondary Education, phrase 4. 2 weeks time to file their affidavit. Prayer made is not objected to by the council petitioner. Release the matter after 2 weeks, by which time the respondents will endeavor to file their affidavit.
Review, my lord, but that
You have preferred?
review.
What is the status?
Sir, may kindly peruse the last order, the detailed direction of this honorable. In review, which they claim to file, it's not numbered, Lordship, even if they might have filed, Lordship. So there was direction to file compliance reports.
What is the status of the review?
Yet to be listed.
So we are issuing contempt notice.
That is being said for long, Lordship. Petitioner is about to retire.
Where is the
Lordship.
direction of the court?
So may kindly peruse order dated 24/6/25. 24/6/26.
This contempt petition is filed being agreed by the non-compliance, willful disobedience and non-compliance of the directions contained in the order dated 28/2/2025, passed in WPC 874 of 2025. By the said order, the following directions were issued. There are 14 onwards, 14, 15, 16, 17. So, since this order has not been complied with, the petitioner has filed the contempt petition. Notice in the matter was issued as far back as 22/8/2025. So, several matter was listed on several dates. However, it appears that the order has not been complied with. Stop. On 16/3/2026, a submission was made by the council with the sole respondent that a review application was filed today. Therefore, prayer for adjournment was made, which was granted. Stop. On 24/6/2026, again, the respondents submitted before the court that review petition filed. But the same was not listed. Therefore, the court directed that the review that until the next, by the next date of listing, either the review petition is heard, and in the event there is no interim order passed, the order dated so and so passed in WPC so and so is required to be complied with, and a compliance report be filed before the court on 10/8/2026. Stop. Today, when the matter is listed, MSS Sutia Learned Counsel appearing for the sole respondent submits that the review, although filed, has not been listed. No compliance report has also been filed before the court. Considering the above, this court considers it appropriate to issue notice and draw up proceedings under the Contempt of Courts Act 1971, read with the Gauhati High Court rules, Contempt of Court rules. Notice be issued thereunder to the sole respondent to show cause as to why the proceedings under so and so should not be drawn up, and consequential orders thereon be passed. Matter be listed after 4 weeks. We are issuing notice. There is an order of the court. Orders of the court are not to be flicked around like this. Once an order is passed in the presence of the council, we expect the order to be given its due respect. You are a council, you are an officer of the court. Not your fault. If the office, we are not drawing up contempt against you. Right? You can only represent the client if the client refuses to understand the consequences.
It is our mistake. That is why I'm praying. So CS already filed on 16.
Your fault. You explain, you and your clients explain that why the matter was not listed. What steps have you taken?
As a last step. Any date after
No, mere listing is not enough.
Madam, we will do the necessary steps for listing and let them after 2 weeks anything.
You do it. In the meantime, we'll see. Then by the next returnable date, you give us a copy of the order of compliance or whatever else you want to.
That may be reflected in the order.
Huh?
That may be reflected.
Not necessary. We are drawing notice of contempt on that date. If we find that the order has been complied with, we may not proceed.
Right.
We may still proceed. May not proceed.
Okay.
May I please, Your Lordship, kindly pass over for time being?
Pass over today. On whose behalf are you making?
Your Lordship, BK Sen.
It is submitted by the council for the petitioner. The matter be passed over to the prayer bail is there any interim order?
No, my lord, since for stacking out respondent number 8, my lord, the IA was filed.
By whom?
By me, my lord. By the petitioner number 7. Governing body has been made as respondent number 10. And since he has withdrawn his name from the repetition, meaning thereby pendency of the this respondent number 10 does not stand by, and it will interrupt us otherwise. He claim against this governing body, against this college, Sapekati college. Principal.
What has happened there? There is no claim.
There is no claim. Since he has already withdrawn the name.
Who has withdrawn?
Petitioner number 7.
7.
Lordship will find, I have enclosed the order, my lord. The Lordship will find the order.
Petitioner 7, Hemanta Kumar Borua.
Lordship, Borua.
Is there an interim order? Is there an order passed
yes,
in an
yes.
IA?
Yes. Page 13, Lordship, in my IA.
All right, then we allow the IA. The IA number 7. The IA has been filed by governing body of Sapekati College, represented by its president, Sapekati, in the district of Sibsagar. The petitioners have filed petitions claiming their regular appointment as principals of the concerned colleges stop. Insofar as the applicant is concerned, writ petitioner number 7, being Dr. Hananda Kumar Borua, who was the in charge principal of Sapegati College, district of Sibsagar, had made his claim for being appointed as the regular principal of the Sapegati College. Stop. Tell me one thing, it's for the education department. In charge principal of one college is required to be made a regular principal of that college only. Then petitioners, including petitioner number 7, they're working as in charge principal. However, steps have been taken by you have initiated steps for regular principal.
Already in my college, already it has been
Steps have been
appointed.
taken by the respondent and the higher education department and the college authority initiation of appointment by way of direct recruitment as mandated under the rules of so and so. What are the rules? What rules?
This is Assam.
So and so for appointment of regular principals in their respective colleges. Stop. So
This is the Assam College Employees Provincialization Service Rules 2010.
Assam College Employees Provincialization of Service Rules 2010.
In my college, already principal has been appointed after due process. 5.1 and 7.8.
Under such circumstances, claim petitioner number 7 rise will lie against the applicant Sapegati College unless a challenge is made to the appointment given to its regular principal. So, be that as it may, by filing an IA, the petitioner number 7 has already withdrawn from the present proceedings and does not wish to press the claims against the governing body, Sapegati College. The IA has been filed, whereby the name of the Sapegati College sought to be deleted from the array of respondents. Prayer made is not objected. Any objections?
No.
Prayer made is not objected to by the council, as also by the council appearing for the respondents. That view of the matter, the IA stands allowed. Name of the Sapegati College deleted the array of respondents. Stop by deleted as respondent 10 from the array of respondents. Stop petitioner will file amended post title before the registry within 2 weeks. Matter will be listed thereafter. In view of the order passed today in the IA, name of so and so will be deleted as respondent 10. Petitioner will file amended post title. Huh? Order availability দিব তাত পঠিয়াই দিও যোনটো ৰেজিষ্টাৰতে পঠিয়াই দিও এইটো ব্লেংক আহিছে ফিল আপ কৰি ইয়াত দি দিও অৰ্ডাৰ টাইপ হ'ব
But the matter may be fixed before Lawadima for postal practice.
It's not dated 5/8/2026 reflects any card with respect to respondent 1, 2, 3, 4 is still existing. after 4 weeks.
As per office note dated 6/8/2026, the service is not
As
complete.
per office note dated 6/8/26, service report is awaited from the sole respondent. Matter therefore be listed after 4 weeks. Yes.
So the government has submitted certain documents. Petitioners were given new appointment.
Yes, they have accepted the appointment, they have joined, they are getting the salary profit in those cases, and in a similar circumstance, the coordinate bench of this honorable court.
No, first, let us see what is the, by which order you are saying that has not been complied.
So, at page number 11.
11. Where is the direction of the court?
At page number 14.
Page number 4.
It's from second line last part. It is hereby directed that the read petitioner be paid their arrear salary as well as current salary. It is provided that the salary shall be paid within a period of 2 months from the date of receipt of a copy of this order, and as regards the payment of arrear salary. Now, what happened of it? There was a division judgment of the honorable court, whereby all those illegal and irregular teachers, they were directed to appear before a screening committee. Accordingly, the government has constituted a screening committee. All these petitions appear before the screening committee. The screening committee found them to be irregular and irregular lordships. Thereby, they were appointed regular appointment. They have accepted it with a condition that they have not claimed the area salary. They have joined. They are getting their salary right now, lordships. So when they have participated in the screening process and they accepted a new appointment with a condition that they would not claim the area salary, and they have joined and they are getting the current salary lordship. So lordship, that in that case we have already complied, and that lordship, and in the similar order lordship, this coordinated lordship has closed such kind of contempt where you observe that they have accepted the conditions and they have joined.
What do you say?
Your lordship, my view is that my submission is before this honorable court is that they have accepted the new salary because they were not provided salary in the earlier service. So mere giving them appointment, the earlier, what is their right? Their service provided their salary right.
You are now before the court alleging willful disobedience of an order, right? Now, whether your acceptance of the job will take away your earlier claim to salary, arrear salary, is an issue that you have to independently urge.
Yes.
So far as this contempt petition is concerned, it is only directed towards release of arrear salary. Now, in the meantime, contrary to the directions, you have accepted the conditions given by the respondents, saying that you will accept and not make any claim.
And they have participated in the screening process on their own. In this regard, my submission is that a judicial order cannot be taken away by this kind of undertaking for government notification there. It's a court order. So it is directed. So how can by this kind of agreements, or as per contract section 28, the judicial order cannot be prevented by this kind of orders. So from current salary, I may not be given because I am joined a new appointment. But what about the arrear salary for which I have provided service? Mere undertaking or no, in the appointment letter, there is a condition that they will not claim the arrear salary. They have accepted that condition. They have accepted the appointment letter. They have joined. Now they are getting the salary. And I have given a similar order logic from 3 different coordinate-based logic. That contempt, similar contempt cases were closed because they have accepted the appointment letter.
But by where is that order of acceptance? Is it here?
I have given that bounce logic last occasion logic directly to that bounce.
Yes. What is the name of the petitioner? Nirupama.
Seven. I have given a flag mark notice. It starts from there.
We've accepted this.
We have accepted the new appointment. There is no dispute in with the condition that they will not claim the area salary.
But
No, court, where is court? Yes, in the appointment letter itself, bro. The appointment letter is there, but in written we have not accepted. The appointment letter itself is the complaint. So that kind of consent or that kind of notification from my
then
part.
you'll have to challenge it.
Yes, they have not challenged this till that.
You challenge this order.
My submission is that disregard, the judicial order cannot be taken away by the scan.
In the order which you are seeking compliance, was this under consideration? Was this particular appointment order under consideration? No.
No.
So you having accepted this, according to you, you have accepted it. But you willfully did not abandon your claim.
Yeah, we
Right?
have not abandoned.
But this will have to be decided by a court of law, for which you will have to challenge, make a separate challenge.
So our opportunity should not be closed by the that.
You are always entitled.
And my submission regarding that judicial order cannot be taken away. That should also be recorded.
This contempt petition is filed. Prohibitions contained in the dated 22/12/2016, passed in WPC 950/2016, right? Here are 13, 14. It's 13, 14. Stop. During the pendency of the writ petition, the cases were considered by the department, and an order dated 30 January 2021 was issued to the writ petitioner, Nirupama Sohoria, for being appointed as a regular teacher in 124 number Bari LP School. Stop. Stop. The said appointment order categorically mentions that she will not make any claim or any benefit in respect of her services rendered prior to 1/11/2020. According to the court, when the direction of the court was issued, the direction of the court was, according to the court, the direction of the coordinate bench by the order that it's going through, where there was no challenge made to such orders being passed by the government. So, accordingly, in view of the acceptance of the appointment, the conditions mentioned therein by the petitioner, of the view that at this stage the contempt petition can be closed. However, petitioner is given liberty to assail the state appointment order either in whole or in part in respect of the conditions by separate proceedings, so advising.
There are 7 petitioners. All of them were appointed. Petitioners
in this contempt, how many?
7 petitioners. 7 petitioners. Yes, yes. I have given the appointment of all the 7 petitioners. That is there. And the same date. Date is same.
Like contempt petition accordingly.
Obliged. I am for the
Mr.
response.
Order. For all the response.
Obliged.
Please, services are waiting. We'll take fresh steps.
As per office note 7/1/2026, service on responding to not complete petitioner is permitted steps. matter be listed after 4 weeks. Mr.
PM now.
PM Nath appears for the respondent.
As regards respondent number 3 as well, Your Lordship.
On the respondent, where service is reported.
Deeply obliged.
Wait for some time, madam. I have not received the instruction.
Yes. Heller Mazumdar with the petitioner, MSS Suti appears for the respondent.
Can we do-
Since it prays for it, granted 4 weeks time. Complete her instructions and file necessary affidavit and escape for the Directorate of Pension. Released after 4 weeks.
Actually, date may fix there.
Right. 23rd of September.
Of like. Happy New Year. Parcel of a timing. Or even.
No objections filed or not?
Not yet.
In fact, queries were asked, the matter has already been taken up by the arbitrator.
The prayer.
They have come under 11.6, but already.
If I may submit, Your Lordship. Lordship, this is an application under 11.6, Your Lordship. For appointment of a sole and independent arbitrator, Your Lordship. Lordship, pursuant to the Constitution and Judgment, Your Lordship, 2025 4 SAC 641, which was passed on 8 November 2024. Lordship, all arbitrator appointments, one-sided arbitrator appointments appointed but is void per se, Your Lordship. The appointment was made on January 2025.
After the judgment.
Yes, yes. They completely covered, Your Lordship. Void per se, Your Lordship.
That is come under section 14, that is.
Lordship, that is
the
de jure.
De jure unable to perform. That case mandate will be terminated and fresh process has to be initiated in terms of the agreement. They have to go for a fresh arbitration.
No, Lordship, that is in case of
11.6.
ineligibility. This
Have
is
you
void
filed your
per se.
objections?
No, man.
You
Only
intend to file it.
I will file it.
You file it.
Man.
Whatever you want to say it.
Man.
The respondents are permitted 3 weeks time to file their objections.
Master.
Mr.
H. Mozumdar, Your
H.
Lordship.
Mazumdar appears for the petition.
Master.
After 3 weeks.
Master.
Lordship, we are grateful and grateful employees of the borderline users.
Some time to find a case. Although in item number 5, I have received certain
The counsel for the state,
Malo.
Mr. S. Das, submits that you would like to file counter affidavit, he prays for 3 weeks time. Mr. Rakri appears for 411, PTC. Mr. Borua for respondents 5, 6, and 7. None has filed their counter.
None.
All the respondents file their counter within 3 weeks.
Your
Release
Lordship,
ticket
it's a short day.
after 3 weeks. Mr.
Jail of
Appears for the petitioner. Release this matter again after 3 weeks on 11 September.
Alibaba.
Lordship, in this case, Lordship, I need 2 weeks time to file affidavit.
2 weeks further time is prayed for and granted by the responding counsel to file their affidavit. Mr. MJ Chaudhary appears for the petitioner. Is up to 2 weeks. Yes. Anyone for the petitioner? Mr. K. Gugoi, learned CGC, hearing for the respondent, praised for and is granted how much? It's time to file their objections. Release this matter again after 3 weeks. None represents the writ petition. None represents the petition. For the respondent here, CGC, any CGC here? You're a CGC? Ms. K. Pukan appears for the respondents. She is permitted 3 weeks' time to file their objections, if any. Mr. Shukla, you're appearing for the petitioner.
No, appearing for petition this matter.
Yes. Released after 3 weeks.
Okay,
Petitioner appears. See. After 3 weeks.
Okay,
Praise the Lord, sir. In this case, petitioner has received a gratuity amount, Lord, sir, but yes, Lord, sir, but regular pension is not. It is uploaded, Lord, sir, uploaded by the period here on 22/5/26, Lord, sir.
What about pension?
It is uploaded at Kritakota portal, Lord, sir.
Huh?
For regular pension, the proposal is uploaded at the Kritakota portal, Lord, sir.
Then what is the procedure thereafter?
After that, Lord, sir, the pension department will proceed, Lord.
Yes, pension.
It is not a party, Lord, sir. Director of pension is not a party.
Director of pension is not a party.
No.
It's not by accountant general. Accountant general has no role. Huh? You have released the GPF. No. Yes, madam.
Allowed to impede the director of pension.
What have you received so far?
Gratuity is received.
Gratuity is received.
Only pending for regular pension.
MSP Sohoria, learned counsel appearing for the petitioner, submits that gratuity amount has been received, however the regular pension is not received. Ms. Small counsel appearing for the education department submits that so far as the parent department is concerned, the proposal has already been uploaded in the Kritakota portal. And therefore, thereafter, the Department of Pension who has to ensure pension subject verification of the documents which are uploaded. So it is further submitted that Director of Pension is not ready to the party. Whereas Accountant General is ready to the party. So Mr. R.K. Taluka, counsel for the Accountant General, submits that
Lordship, as per this letter, Lordship, they have sent the documents to us. I'll get it.
the documents have also been sent to the office of the accountant general. Submits that he would like to obtain the required instruction in the matter. Meanwhile, the court permits MSK Fukan, government advocate, obtain required instructions from the Director of Pension regarding the release of pensionary benefits claimed by the writ petitioner, notwithstanding that the Director of Pension is not arrayed as a party. Copy of this order be marked SK by the registry, and the counsel for petitioner will also furnish a copy of the writ petition, enabling her to obtain required instructions. Released again after 3 weeks.
My lord, I beg for the item number 31, my lord. I could not appear with
We have recorded someone's name. A. Fuban.
3 weeks.
3 weeks.
My name may be recorded, otherwise 31.
The matter pertains to pensionary benefits, Lordship. I think has been received by the petitioner till date. It's been more than 1 year since she retired. Way back on April.
Yes,
she retired.
respondents.
Department has already forwarded the pension proposal on 13/5/26.
13?
13/5/26.
13.5.
Fine.
To whom?
The director of pension.
Director of pension.
He had a concern.
Yes, director of pension is the party, not party. The claim of the petitioner is for release of pension. Respect of the services rendered by her late husband.
No, by herself, Lordship.
Acha. In respect of the services rendered by the petitioner as teacher
Yes, Lordship.
under the Department of Elementary Education. So, MSS Sutia Learned Council appearing for elementary education submits that the relevant documents have already been forwarded by the Director of Elementary Education for payment of pension to the department, to the Director of Secondary Education has already forwarded it to the Director of Pension for release of the pension. So, Director of Pension is not added as a party, nevertheless, the SKF Open Learned State Council is permitted to obtain instructions and on the request of the court and place the same before the court. A copy of the instructions placed by the Standing Council Secondary Education will be Elementary Education will be handed over to the State Council along with as also a copy of the writ petition by the writ petitioner to enable her to obtain by the instructions regarding the stage of process of the pension of the writ petitioner based after 3 weeks on 11th September. Names of all standing councils, including NSK, will be reflected in the process. Item 31 also. Huh? 32.
All is related to same petitioner, area salary Lordship. Yeah, Lordship.
Let it be listed along with that. Along with the same matter.
Hearing notice was issued on 25/2026. And the prayer of the petitioners are grant of UGC.
Respondents are permitted 4 weeks further time to complete instructions and file affidavit.
I need some time.
They have given you time. Mr. S. Gautam.
S. Gautam.
Yes, for the writ petition, will be taken after 4 weeks.
58 maybe please.
23rd of September.
Gradually.
Yes.
I was under the impression that a reasoned or affidavit, Your Lordship, has been filed, Your Lordship. However, after looking at the record that upon notice, Your Lordship, that has not been filed. May I pray some time, Your Lordship? You can file the reasoned, Your Lordship.
Counsel for the petitioner prays for and is granted 3 weeks time to file a rejoinder affidavit. Mr. Yankat Mazumdar appears for the Chaudhary.
And it's for private
Chaudhary for private respondent number. For the private respondent, MSP Das appears for secondary.
1 and 3.
Released again after 3 weeks.
Okay.
Like,
Three of them.
In this case, two petitioners are there. Both are the science teacher. They were left out from provincialization due to wrong submission of the date of appointment and date of joining. Yet after the provincialization order in 2013, the petitioner immediately approached before the appropriate authority, and that is rectified minor. But till date, their service was not provincialized. But after, on last occasion, your lordship directed to take instruction minor. In the meantime, the petitioner number 1, school was amalgamated with the high school, and he is the only mathematics or science teacher in the high school, still working minor. And I have filed an additional affidavit minor on 14/8/2024, where there is an interim order minor from this honorable court, that is on page 83 minor.
you are not yet provincialized.
Yes, not yet provincial. After several communication was made to the government, but till date nothing has been done. And the petitioner number 1 was petitioner number 2 by the affidavit that her process was already in process for provincialization of her service, but till date petitioner number is not yet provincialized. And petitioner number 1, there is a problem that earlier he was appointed in ME school. Later on, the school was amalgamated with the high school in 2018. 2013, he was his service was not provincialized due to wrong submission of his date of joining. Instead of 2010, it was submitted at 2011. Last occasion, this honorable court directed to take instruction.
We have received one instruction from the inspector of school, and he stated, as per district elementary education officer Lakhimpur has informed that no minutes of district level school committee under the Assam Provincialization of Teachers Act 2011 as amended 2012, 13, 17 and 2018 are available in that office relating to the recommendation of the of Sri Dulal Sharma, Assistant Teacher Science, Bhatti Madar ME School, that are amalgamated with the Bhatti Madar High School, showing the date joining of concerned teacher 27 to 2010 instead of 26/6/2022. However, the DO has further informed that a letter number DOL dropped and so dated 24/8/2018 issued by the then district elementary officer Lakhimpur and forwarded to the Director of Elementary Education Assam in pursuance of letter number so dated 13/7/2018 is available in that office records. The communication enclosed a performer containing the particulars of 17 science drop teachers, wherein the name of Dulal Sharma appears at serial number 8, showing his date of joining as 27 to 2010. This is my instruction regarding that.
But this is contrary to your stand in the affidavit. First affidavit filed by the director.
Earlier, he was appointed in MES. Now, which was under the jurisdiction of
So you
elementary-
come to the affidavit filed on 26 February 21 by respondent 4, Director of Elementary Education. We have a copy.
Yes.
Come to paragraph number 5.
Yes.
Yes. Answering the point, I humbly begs to state that the petitioner's service was not provincialized due to non-recommendation of the district scrutiny committee. So, my lord, and this report has come from the DU. It has come from the DU, and
you direct the DEO is a party here, no?
yes,
The party.
it's a party. Elementary education is party.
You bring it on record. File an affidavit immediately, explaining. Your affidavit filed earlier.
Yes.
Says that the provincialization did not take place because of
non-recommendation.
Because of wrong submission of date of joining of the petition. Para 5, page 64 of the affidavit filed on 26 February, filed by Director Elementary Education.
Director Elementary Education.
Then
It's clarification because the affidavit which we are filing the additional affidavit. Again, there is a report of the DEO based on the additional affidavit that is filed by the elementary director.
Is it enclosed? It is not enclosed.
No, it's not enclosed. But there is a statement made that in terms of the report that has been from the district scrutiny.
Some additional affidavit is filed.
Yes. This additional affidavit has been filed
by the director.
By the director elementary education. In pursuance to the new facts which has been brought by the petitioner in an additional affidavit. Paragraph 6. Yeah, then you know, to state that in compliance with the order dated 12 to 2021 passed by this honorable court, the instant reputation whereby the respondent in the elementary education department was directed to file affidavit with a further observation that pendency of the reputation shall not be a part of the respondent in the appropriate department, secondary or elementary, as the case may be, to consider the case of the petitioner for provincialization of the soul under the provisions of the said Act of 2017 and in accordance with law as per their entitlement. Accordingly, this office of the answering deponent sought instruction from the government by letter dated so regarding the claim of the petitioner for provincialization of her service as per Act of 2007. In the said letter, it was also informed to the government that the school where the petitioner number 1 claimed to have been working, namely Bhakti Medak ME School, was amalgamated with the Bhakti Medak High School on 20/01/2018. Accordingly, the government in the elementary education department issued a letter dated so to the additional secretary of the government of Assam with a request to take necessary action for compliance of the order dated so passed by this honorable court. The present declaration as the school of the petitioner now has been amalgamated with the high school. The government by letter dated so informed that in case of the petitioner Lal Sharma, that is petitioner 1, school namely Bhakti Medak ME School was amalgamated with high school so that the matter of the petitioner was forwarded to the then Director of Secondary Education Assam by letter dated 21/02/2020. Regarding provincialization of service of petitioner number 2, Janmoni Soikia, as a science teacher of Branchpur Janodati ME School, the Director of Elementary officer was instructed to process the matter of provincialization as per the provisions laid down in the provisions of 2015 with due recommendation from the district scrutiny committee and by placing the proposal before the state level scrutiny for further verification as well as the decision of the joint committee in the minute. As the government in view of the amalgamation of so-and-so has forwarded the matter to the secondary for consideration of the case of petitioner number 1, hence the office of the answer and did not possess any provincialization process the provincialization service of the petitioner number 1, Bilal Sharma, as per Act of respect of petitioner number 1. Now, since that school has got amalgamated with the high school,
So then you come to the affidavit filed by the director secondary education. Page 110, para 4.
Recommended by the as reported by the inspector. As per paragraph 4, under the secondary education department, it does reject district scrutiny committee of the secondary education. Instruction which has been placed by the secondary education, by the inspector of schools. The minute your occupied planning. Is number 8. The instruction which has been placed to the
What instruction?
This is the I'll have to take instruction on the second page, the second communication you have to kindly find. This is a clarification by the DO, the inspector of school.
His name is found to be working since 27 to 2010.
2000.
That is as per the report of the headmaster.
His date of joining.
Huh?
His date of joining.
Then why is this report not accepted? Report of the headmaster.
Since there were 2 dates earlier, before there were 2.
But then they have clarified by
Yes,
filing an
yes,
additional
that-
affidavit.
That's they have clarified, my lord. This director of district elementary education officer has also clarified it to the secondary education department.
That?
The letter of 1/8/2026.
Yes, 7/8.
So the EO's letter to the inspector is
1/8.
1/8, and the 7/8 is the inspector's letter to the director, the secondary.
But
now-
counsel for party view of the subsequent instructions being received from the office of the inspector of schools, a district elementary officer, Lakhimpur, inspector of school, which in turn have been placed before the director of secondary education. For one, Mr. B. Portion, Leonard, Standing Counsel,
Department of School Education.
Department of School Education, submits that he be permitted to complete his instructions in this regard regarding the date of joining of the writ petitioner.
The writ petitioner number 1.
Writ petitioner number 1. Praise for 2 weeks' time. Released again after 2 weeks.
Come on 28th of August,
28th,
28th
28th of September.
August, my lord. August.
Sorry, August. 28th of August. Yes.
We have issued the pension payment order and gratuity payment order on 7 July. All already supplied.
Lordship may be taken up in the next week. I will take instruction from the client.
Counsel for the petitioner submits, counsel for accountant general
Lordship.
submits that the gratuity and
Pension
PPO
payment order,
has been issued on
7/7/26.
7/7/26. Counsel for the petitioner submits that he be permitted to obtain complete his instruction. Mr. B.D. Goswami appears for respondents 4, 5, and 6. Released again after a week.
Yes, sir.
Lordship, I am appearing in person. The grievance is delay in disbursing pension, which is due for last 20 years, Lordship. And I am receiving provisional pension for the voluntary retirement, Lordship. Under the modification rule of Assam Service Pension Rule, FAPSC 976, 29th April of 1976, Lordship. The present status is, Lordship, on 26th May 2026, the respondent number 5 has submitted a letter which has come from the Joint Secretary to the...
Just tell us what is your revenge? Why are you before the court?
Yes, Lordship, I have joined the organization
Which organization?
Victoria Girls Higher Secondary School in Dibrugarh
Right.
on 9th April 1991. And I have taken voluntary retirement on 1st January 2006, which has been approved and sanctioned by the respondent number 5 on the basis of modification rule of Assam Service Pension Rule, FAPSC 976. If Lordship comes to the page 20 from 27, Lordship, and here is the respondent number 5 who has approved on 5/5/2009, Lordship. And it has been mentioned that I have worked for more than 10 years. After that, if we come to page 28, Lordship, the order in...
You had applied for VRS.
Voluntary retirement, yes, Lordship.
Then?
Then, Lordship, it's been approved by the respondent number 5. That is the director of the secondary education on 5th 2009. Then, Lordship, if you come to page 28, here it is been allowed to go for voluntary retirement by the inspector of school. That is on 14/5/2009, page 28. Now, Lordship.
Yes.
Here we have assigned the OBC non-criminal certificate purportedly issued to the respondent number 7. But what had occasioned this? The respondent number 7 is the daughter of the petitioner. Now, Lordship, spouse of the petitioner submitted an RTI application to the authorities.
Who are you?
Lordship, I am the mother of the respondent number 7. The certificate to whom it has been issued. Now,
Certificate?
Lordship, OBC NCL certificate, non-criminal certificate. Lordship, our case was that the certificate was issued in 2012. 3 years prior thereto, our income was more than 4.5 lakhs. Therefore, my daughter could not have been eligible. Now, Lordship, we preferred an RTI application initially, wherein the reply was that no certificate was issued to respondent number 7. On the basis of that, Lordship, we submitted an application to the representation to the IGNOU authorities, stating that the B.Ed degree which my daughter had taken, showing herself to be non-criminal, is against the reply which has been given by the authorities. Thereafter, the authorities again modified the reply, stating that instead of it was not issued, it should have been records are not available. That was the second reply. Now, thereafter, Lordship, we came up before this Honorable Court. Honorable Court directed the IGNOU authorities to consider the representation, wherein the authorities again stated, revenue authorities, that certificate issued to respondent number 7 is genuine, and the signature is also correct there. Thereafter, we again made an RTI application that please give us the documents which were submitted by them. Now, the authorities say that the building is in a dilapidated condition and therefore the documents cannot be given to you. Now, every reply, the stand is being changed. And ultimately, now my respondent number 7 has also filed their affidavit in opposition, wherein, subject to what my learned senior would argue, their stand is that.
You are seeking information from which department?
Lordship, it is from the Subdivisional Officer, Lakhipur, Lordship, Revenue and Disaster Management.
Revenue and Disaster Management. What is the format necessary for the application?
Lordship, the OM office memorandum states that it should be to the sons and daughters. It should be based on parents.
Where is the OM?
Lordship, the office memorandum is on page 31.
So you show us from the time of application whether your signatures are required or not required.
What the respondents have filed in their affidavit is that the respondent number 7 was married in the year 1998, and therefore subsequently she is not dependent on her parents, and therefore question of parents' income will not come into effect. That is the stand of the respondent authorities.
Fair enough.
Lordship, therefore the only question which your Lordship is to determine is whether the OBC NCL certificate can be issued based on own income or spouse income, or has it to be issued only based upon parents' income?
On what basis are you saying it cannot be cited on the spouse income?
Lordship, this OM, page 31, married. The undersigned is directed to invite the attention of this department OM dated 8 September 1993, which inter alia provided that sons and daughters of persons having gross annual income of rupees 1 lakh or above for 3 consecutive years would fall within the criminal and others would not be entitled. This was subsequently raised to 2.5 lakhs. It has now been decided to raise the income limit from 2.5 to 4.5 per annum for determining the criminal amongst the OBCs. Now, Lordship will see category 6. Description of category, income/wealth test. To whom the rule of exclusion will apply. Lordship will see sons and daughters of persons. Now, Lordship, this was clarified.
What is these categories 1, 2, 3, and 5?
Lordship, for that, if I may lay upon an OM of 2004, wherein this was clarified, the question whether the spouse's income can be taken into account or not. The categories are mentioned in paragraph 4, page 54 of that. Paragraph 4. So the categories. One is, will the sons and daughters of parents, either of whom or both of parents are class 1 group A officers? Will sons and daughters of parents, lordship relevant, your lordship will find? At paragraph 8, what will be the status if a person is married? Or whether her or his own income can be taken into account. Paragraph 8, married, lordship. In regard to clauses 6, 7, and 8 of paragraph 4, it is clarified that the creamy status of a candidate is determined on the basis of the status of his parents and not on the basis of his own income, own status or income, or on the basis of status or income of his or her spouse. Therefore, while determining the creamy status of a person, the status or the income of the candidate himself or his or her spouse shall not be taken into account. Now, this OM clarified that the only NCL certificate can be issued only based on parents' income. His or her own income or spouse income cannot be a consideration. And this was subsequently upheld by the Honorable Apex Court.
Familiar. Yes. You are challenging the issuance of the creamy layer certificate to the respondent.
Yes.
Who has issued it? Private, that government.
Government.
Who's for the government?
RTA replies by the authorities. The stand is being.
There is no affidavit.
No, Lord.
Why no affidavit by the government? The circle officer.
Circle officer.
Who appears for the circle officer? Deputy Commissioner.
Deputy Commissioner to respondent 3.
Who is for Deputy Commissioner? SDO. Who appears for Deputy Commissioner? What do you have to say? Get instructions as to how the whether the creamy layer certificate is issued on the basis of this OM. You have a copy of the OM. The petitioner has assailed the issuance. Yes, Mr. Kauravat.
My submission is only limited here. Whatever contention my learned friend has raised, has taken. Now, at this moment, I feel that these contentions are obliterated in view of the fact that your lordship remembers just the other day there was another case between the same parties connected to educational tribunal, where this respondent number 7 herein, she is already dismissed from service way back in 2020. The school of which my learned friend's clientess is the principal. In that school, my clientess was serving as an assistant teacher, subsequently the vice principal, and then eventually she was demoted again and thereafter put to suspension, and eventually she was dismissed for service, against which she preferred appeal before the educational tribunal. Regarding some production of documents, there was a writ petition pending. Your lordship has passed an order just the other day in WPC 182. So my humble submission is, her grievance, to the extent that I had been issued a non-familiar certificate which I ought not to have been. How is she affected, being the principal or being my erstwhile employee?
No, your mother.
My
Your
mother,
father.
who is the principal in the capacity of principal of the school in which I was serving.
No, this creamy layer is to be issued on the basis of your family.
No,
standing.
that is true, but he is agitating this issue in the capacity of the principal of the school, in which I was the employee. Now, she being the employer at that point of time, she has agitated this grievance after 12 years because she is basically aggrieved with the B.Ed certificate that I have procured on the basis of this non-familiar certificate.
Now, she is aggrieved by my credentials, she is aggrieved by my testimonials. In what capacity? As an employer. But as on date, she is not my employer anymore because she has dismissed me from my service way back in 2022. So her locus standi as on date to challenge my non-criminal certificate or the B.Ed degree that I have obtained on the strength of that non-criminal certificate, that is obliterated, my lord, in my humble contention, subject to correction. Because her locus standi as on date is not there. Yes, in the educational tribunal, if I succeed and my post is again rejuvenated, if I'm again reinstated, then again my relation with her as employer-employee.
No, that is okay, but if you are not entitled to be issued a criminal certificate, are we?
I'm not saying, my lord, that
stopped from inquiring as to how a criminal certificate has been issued on the basis of the income of the spouse.
Now, even if it is to be based on the income of my parents or my the income of my mother, who is
and
the
you have raised some complaints before the DC. Those have not been answered.
Those have, my lord, these things are going on. But only thing is, my lord, even if on that count also, if I am to respond, I have already filed my
The issue before the tribunal is regarding your dismissal.
Dismissal on the grounds of many anomalies. One of which
it may be.
One
This
of which is
this is essentially you are the beneficiary of a particular action which, according to the petitioner, was taken contrary to provisions.
to the extent of getting that non-criminal certificate. But my lord, the usage of that non-criminal certificate to get a job in that school, that as on date is not there.
No, it is about getting a B.Ed degree.
Yeah, that on the strength of that B.Ed degree, I was appointed in that school. Now, if she is to be aggrieved by my B.Ed degree, that has to be for using that B.Ed degree to get an appointment in the school, in my understanding.
Why? What we want to find out is whether
Well, that obviously this honorable, since they have raised this issue,
you'll have to answer this
well,
issue.
I have answered it only in that respect. I have answered in my affidavit.
You're submitting before the court that since the educational tribunal is dealing with the inter se matter, this has lost its significance.
That is one aspect.
But the certificate remains. You have not surrendered the certificate.
No. That certificate remains, and again, even insofar as the
Well, let the respondents
let them
take their instructions and tell us.
Yes, let them respond.
Heard counsel to the party by the issuance of a non-criminal certificate in favor of the private respondent by showing the income of the spouse, of her spouse. Stop. The petitioner is the mother of the private respondent number 7, and according to her, the private respondent 7 is not in the criminal, and particularly the income of her spouse, of the respondent number 7's spouse, would not be used as a yardstick, would not be used as measure to issue the non-criminal certificate, as have been done by the who has released the certificate, issued the certificate, circle officer.
The certificate has been issued
by the circle officer / the deputy commissioner, Kachak. Stop. The other respondents have filed their affidavit. However, the state respondents are yet to file their counter affidavit. Stop. MSN K. Fukan, the State Council, prays for and is granted 3 weeks' time to complete her instructions in the matter. More particularly, with regard to issuance of a criminal, as to whether the non-criminal certificate issued to respondent number 7 was issued by adhering to the this memorandum dated 14th of October 2000, where it is clearly specified that for issuance, where it is clearly specified at clause 8 that criminal status of a candidate is to be determined on the basis of the status of his or her parents and not on the basis of his own status or on the income or on the basis of the status or income of his or her spouse. Let this instruction be placed before the court by the next date. Released again after 3 weeks.
May I pray for a fixed day? That should be furnished.
The counsel for the petitioner will furnish extra copies to the respondent for obtain the required instruction based on 26th.
26th of when?
Based on 11th of September.
11th. All right, sir.
Let me tell us. Basically, also petitioner has challenged the appointment of respondent numbers 6 and 7. Basically 7 or 6 lordship. 7 is his good the best first position. So
all pleadings complete.
lordship pleadings is complete. And respondent number 3 has filed the affidavit in opposition, which we have replied also. Other parties also private respondent has not appeared. Probably the state is lordship representing them.
One aspect, the method. There are certain specifications, certain when by which the standard for selection was laid down. If that perhaps is not on record, may be required.
Who will bring it on record?
Lordship, I'll produce it on the next date if Lordship permits me some time. Perhaps 2 weeks. I'll produce the office memorandum.
You have to bring it on record.
Lordship,
You
it was
want
not in the, I've checked the affidavit. Even the one that we have filed, we have not annexed it. That will be
Mr. Rathriel, Learned Standing Council, BTC,
Yes, sir.
submits that certain relevant office memorandums are required to have been brought on record, but same are not available. The affidavit filed. He therefore submits that he be permitted to its time to bring it on record by filing an additional affidavit.
But fixed that because 2024.
Mr. Jayapurita appeals for petitioner based on 28th August.
Before that, they will file as a public provided.
The affidavit is prayed for be filed before the next date of listing.
There is an interim order that will come.
Interim order, if already passed earlier, will come.
Please, Your Lordship. Also, here the petitioner is not being deprived of their due recruitment, Your Lordship. And then interim or recruitment in their provincialized schools of Assam, Your Lordship. Subsequently, an interim order has been passed in this matter, Your Lordship, on 3rd November 2025, wherein 4 posts were stayed. Also, wherein pleadings have been completed.
Submitted the pleading matter. In the month of September.
On 3rd of September.
What date it will come? And September.
Wait, please, Your Lord.
Yes.
As per order dated 26/6/2026, my lord, Honorable Court allowed the respondents to file affidavit as a last chance.
Not file.
Not file. On occasions.
For the respondent, secondary education.
Secondary.
Fine.
Too many times the matter was done, but
what is your grievance?
Grievance is that, my lord, from my lord 1993, he was working as a Hindi teacher, and thereafter he was subsequently upgraded as senior teacher, my lord. And on the basis of ad hoc, and they received all scale of pay from the date of joining as a regular income, but post was not regularized. So many communications are there, and directors asked so many, my lord, format, but they did not do it, my lord. And next year, my lord, he is going to be retired, my lord. 31/10/2027. So, and there is a Manohar committee also, he was appeared. And same, others was regularized, petitioner was not regularized today. He's a MA, B.Ed and everything is there. And upgradation order, my lord, page 58.
Since as per order, as per the last order dated 26/6.
Lordship, in this case, that hearing is scheduled on 13/8/2026. Where the
What
petitioner is also called by the expert committee to appear. Lordship. The matter will be fixed after 13. So we will submit the outcome of the hearing.
hearing before which committee?
Lordship, I am just giving the instruction.
Huh?
I have received the instruction.
No, hearing before which committee?
Sir, I have examined the claim of the petitioner. For a directorate. Lordship.
Hearing for what purpose?
Regarding to examine the claim of the petitioner.
Is there any direction?
No, Lordship, because I am sharing that instruction. Lordship.
Yesterday, I also communicated to my client, my lord. Till today, we have not received any notice.
Who has directed the hearing?
Lordship, the old pending matter is up to started from 1996. The hearing was
Huh?
in the
I have not understood what you are trying to submit.
petitioner is claiming the service utilization of it.
Hmm.
Well, okay.
So
that matter.
you have not done it, so it's before the court now.
Yes, yes.
Under
That's
what
why
orders
in
is the
order to-
director proceeding with the hearing?
In order to resolve the issue, Lordship,
Ah.
that hearing is directed in the total by the department.
Where is that notice?
Lordship.
Have you issued notice to the petitioner?
That instruction, Lordship, I have not, but it is.
But as per annexer page milo 99, my lord, there is a order issued by the deputy director on 22nd of March 2018. Your lordship, go to page 99. But they asked me some, my lord, documents regarding last year ACR scanning report, incumbency of the list school made. But from 2018, they do not do it, my lord. Page 99. My lord.
That petitioner will appear before a director, Lordship, for one from 13.
Is the director going for a parallel hearing? When the court is in session of the matter, how is the director continuing a hearing and then giving me instructions that the matter is listed for hearing? Thereafter, she will give instructions as to how the case is to be conducted.
Perhaps that is not Lordship, but to get the entire matter resolved.
That's what we are asking you.
Presence of the petitioner is also required.
Presence of the petitioner is ready, but is the director aware that the matter is pending?
Yes, he
Is the
aware,
director
Lordship.
aware that by the last order, you've been given a last chance to file your affidavit? Is the director aware? Have you communicated?
Yes, that yes, sir, it was communicated, and this order is also issued in reference to that petition. Subject is.
Well, we'll call for the director. Let us understand, since you are unable to explain, let us call for the director and find out what is going on. Ask the director to be present.
And I will pick on 14 Lordship, I will get the detailed instruction on this matter.
Yeah, we have given you enough time.
Lordship, correct.
Then
But one last chance may be given as
one last chance is for tomorrow. You get your instructions tomorrow.
as department is also willing to resolve this matter.
What is this going on? What kind of advice are you giving to your clients? You have no idea under what provision the hearing is being conducted? Have you received any notice?
No.
Then?
One line they have mentioned Lordship. After completion of the hearing and verification of the record of document of petitioner,
Direct counsel for the parties. This writ petition is filed by the petitioner, praying for the regularization of his services as the Hindi teacher. Since the matter was issued as far back as where was notice issued? When was notice issued? Not issued. A notice was issued on 7/11/2025.
Right.
Thereafter, opportunities were granted to the respondents to file their affidavit, but the state respondent does not file their affidavit. By order dated 26/6/2026, this court had directed, granted the respondents time till 3007 as the last chance to file their affidavits. The matter was directed to be listed today. Stop. When the matter is called up, Mr. P.P. Dr. Standing Counsel, Secondary Education has placed before the court a communication from the Director, Secondary Education, that a hearing is fixed on 13/8/2026 at 12:30 p.m. to examine the claim of the petitioner. And after completion of the hearing and verification of the records and documents of the petitioner, necessary instructions shall be prepared and issued forthwith. And prayer is made for obtaining 3 weeks' time. The counsel for the petitioner on appointed query by the court submits that no notice has been received or received by the petitioner or issued by the director in respect of the hearing, which is stated to have been fixed on 13/8/2026 at 12:30 p.m. So, the orders which are passed by the court pursuant to issuance of notice does not reflect that there was any direction to the director to conduct the hearing regard to the claims of the petitioner. The claims of the petitioner not being redressed, the petitioner is before the court. When the court is in session of the matter, since the date of issuance of the notice, the attempt by the director to go for parallel hearing of the matter without any leave is strongly deprecated. Such conduct of the director could reach in a matter which is presently pending before the court and where the directorate is represented by standing counsel is certainly not expected of a responsible officer, post of a directorate of secondary education. The director is therefore asked to furnish the reasons and the grounds on which the directorate is proceeding to hear the matter without leave of the court. Matter be listed on 13th, by which date the director will apprise the court, failing which the court will issue consequential orders. Copy of these orders be marked to the standing counsel for onward communication. Released on 13th. We are stopping short of issuing contempt. You are first an officer of the court. Your duty is to the court first. You must be responsible to that extent. Any and all instructions are not to be placed before the court. Yes.
My checking for pass over for the time being.
Why?
My senior is on the way.
On the way?
Yes, your loss. Actually, she's a legal aid counsel.
In this case, one IA has been filed to complete the UGC and perhaps
Taken after some time.
Before the court rises.
Yes, sir.
That is all. The matter relates to my lord payment of my lord compassionate family pension loss. My lord, the petitioner was my lord initially joined as my lord contractual my lord Mr. Loshi on 8/9/2017 loss. Hereafter, my lord, on reading my service Loshi on 5/8/2024, an advertisement was issued Loshi to accommodate my lord such discharge lordship in the vacant post lordship. Accordingly, the condition, my lord, is the my lord, that there are past service in the my lord, as a contractual basis. These are like the petitioner. Accordingly, the petitioner submits the application online lordship. Thereafter, my lord, she was selected and appointed lordship on lordship 2/9/2024. In continue of the earlier service lordship, he again, my lord, formally joined in the same post, same category lordship. My lord submitted joining letter. Actually, he was continued in that post lordship. He was in service lordship. Now, on 26/1/2025, she, my lord, expired lordship on my lord while discharging lordship. Now, my lord submitted application under the scheme of compassionate appointment, family pension lordship in lieu of compassionate appointment that was introduced on my lord 14 by notification dated 14 September 2017 with effect from 1/4/2017 lordship. But that application has not been finalized, lordship. My lord, the respondents were sitting over the matter, lordship. Now I have submitted. I am accordingly writ petition is filed, my lord. The respondent, my lord, has appeared, my lord, and submitted filed an affidavit, lord, saying that the petitioner, my lord, did not complete 1 year service for the for my lord claiming the compassionate family pension, lordship. Now, in a similarly situated case, lordship, my lord, this honorable court, my lord, has pronounced judgment, lordship, saying that in case of my lord compassionate family pension, the pension rules, my lord, shall not be strictly complied, lordship. That judgment has been annexed in this petition, lordship. In the meantime, lordship, the rule has been, my lord, amended in 2022. My lord, introducing the my lord clause of my lord compassionate family pension for saying that the continuous 1 year service. Of course, the petitioner has continuous 1 year service, lordship, more than 1 year since 2017, lordship. Same post, my lord.
But not after regularization.
My lord, not my yes, lordship. After my lord, fresh my lord appointment, lordship. That is actually regularization, lordship. As
Where is the order of fresh appointment?
My lord, that is at page, lordship. At page 24, lordship. My lord, before that, may I draw your lordship's attention in the advertisement, lordship. At page 21, lordship. My lord, kind of my lord advertisement, lordship. The condition is, my lord, page 21 and except 4, lordship. 21, lordship. The advertisement, lordship.
Yes.
Now, my lord, close condition number 6, kindly see, lordship. May I read, lordship? A candidate shall apply in the same category of post that she was holding as contractual or state full contractual teacher and only in one post. My lord, I applied in the same post, lordship, where I had been continuously working, lordship. Now, the appointment order is at page, my lord, 24. My lord, where is? It was on 2nd September 2024.
Where is that order?
My lord, 2nd September at page 24. Annexure 6.
Yes.
Now, my lord, kindly see my joining letter, lordship. I have stated in joining letter at page 26, lordship. I have already joined, lordship. My lord, at page 26, lordship. Relevant portion, may I read, lordship. Respected sir, madam, with due respect, I'd like to state that I am appointed at Kopni Kusi LP School as assistant teacher by appointment letter number so and so, dated 2/9/2024, issued by the Director of Elementary Division, Assam. Yes, sir. Madam, I have already joined the school in accordance with the directions of the above mentioned appointment letter enclosed here with lordship. I was already in school, lordship. My lord, attendance register is there, lordship. No gap is there, no break is there, lordship. Now, I applied, my lord, that was not finalized, lordship. Now, in the meantime, another case, lordship, in which, my lord, 1 year continuous service was not, my lord, stated to have been, my lord, completed, my lord, the compensation family pension claim was rejected, lordship. This honorable court, in that case, my lord, has formulated some, my lord, directions, lordship, has issued some directions, lordship. At page, that judgment is at page 40, lordship, 40, annex 40. My lord, may I read, lordship, may I draw your lordship's kind attention at page 52, lordship. My lord, relevant directions, lordship. Paragraph 26. May I read, lordship. From a careful reading of various clauses contained in the notification dated 14/9/2017, this court is inclined to accept the contention of the learned counsel for the petitioner to the effect that her claim for CPF is covered by CPF scheme for the following reasons. Firstly, there is nothing in the scheme which excludes a temporary fixed pay government servant from the ambit of the scheme, provided his service is subsequently confirmed. Therefore, in view of the definition of the government servant provided under the rule of 1964, this court is of the opinion that a restrictive construction of the proviso to Rule 5(3) would defeat the very object of this scheme and therefore ought to be avoided. Secondly, that Manik Chandra Rai has served under the government BTC continuously since 2028 to 2011 till his demise on 7/12/2018 without any break, and therefore he had evidentially completed more than 1 year of continuous service. Fourth, lordship, D. Fourthly, the CPF scheme is not intended to complement the rules of 1969, but the same, in the opinion of this court, seeks to carve out an exception to the rules of 1969. Inasmuch as the CPF scheme is aimed at extending benefit to the family members of those deceased government servants dying in harness who are not covered under the rules of 1969. Therefore, it would not be permissible for this court to rely upon the provisions of the rules of 1969 so as to adopt a restrictive interpretation of clause 5(3) of the CPF. Now, clause 5(3), lordship, my lord, the honorable court, my lord, has, my lord, quoted, lordship, my lord, at page 47.
Where is the scheme?
My lord, it is, my lord, scheme is, lordship, not annexed, but it is, my lord, this court 5(3) is quoted in this judgment at page 47, lordship. Yes, kindly, my lord, lordship, kindly come to page 47, lordship.
Yes.
My lord, clause 5(3), my lord, the relevant paragraph I am reading, lordship, clause. Where the employee dies before superannuation, the family pension equal to 100% of the last pay drawn by the deceased employee be paid for a period up to the date of deemed superannuation of the deceased employee. That is the date on which the employee would have superannuated had he been alive. This would compensate the loss of family income to a large extent and fulfill the requirement of compensation conditions arising out of the death of the serving employee. However, the government servant must complete minimum 1 year of continuous service without break before death while in service. My lord, this clause, my lord, this honorable court, my lord, proviso, honorable court has directed not to, my lord, comply, lordship. In my case, lordship, I was continuously in service, lordship.
Where is that direction?
My lord, direction at page 26, my lord, paragraph 26 of this at page 52, lordship. Already, lordship. Paragraph 26.
Yes. Here, my lord, we have filed our affidavit. My lord, we have bind by this notification.
Why there is no dispute on facts?
Well, it's true. My lord. Only thing is that the rule has already been amended.
What is that rule?
Well, page 36. Annexed 13, my lord.
Yes.
In exercise of power conferred under the proviso of Article 309 of the Constitution of the Government, some pleased to make the following rules further to amend the Assam Services Pension Rule 1969, herein referred to as the feasible rule in the manner hereinafter appears named. Here, inserting new rules, 142A. A. Next page, also will find 111.
1 year of completing service.
My lord.
Continuous.
My lord. It is where we have bind by this. Petitioner has
This
not,
is what is clarified in the judgment.
but my lord, to my understanding, my lord, this rule has not discussed.
May not be, but the ratio is there. Otherwise, there is no dispute that he was rendering service as a contractual employee. Then absorbed in the same post. Continued for 6-7 months, then expired. Now, for this benefit, why the services rendered earlier cannot be.
Here, kindly see page 24, my lord, and exercise 6, my lord. Page his order of appointment, page 24 and exercise 6. 24, order of appointment.
We have seen it, 2nd of September.
Kindly see number 3, point number 3. The appointee concerned will get basic salary with admissible allowance and the first increment by given only after 1 year of satisfactory service. No claim, pay protection for the past work, etc.
Are you saying that she's not got her salary?
That is true. I'll say it's for the compensation.
You've not got the salary.
Huh? Got loss.
Receive.
Well, let's see as for the compensation, but only we are bound by this rule.
That rule has been clarified. Even otherwise, there are so many judgments of this court and the apex court that the services rendered in the temporary service will be counted towards pensionary benefits. If otherwise found to be eligible. There is a shortfall of few months. From September, she expired in?
Expired on lordship 26/1/2025.
26 January.
Only 4 months.
So, 4 months she has.
CFs have 4 months, 10 days.
This is not a fresh appointment that she has been.
Well, defect from the advantage. What's it name? Only discussing this.
What do you say regarding the judgment?
Judgment, I have gone for it.
What? Where are those line of judgments?
Sorry, Lordship.
Obiram Rajbamshi and all that, you have it? No.
Not taken into the Lordship. That was my Lord.
Right, hard response. Passholders. Item number
50 Lordship. How like that?
We are allowing the writ petition, directing the petitioner to be considered towards a claim for compassionate. Compassionate family pension. By bringing the services rendered in temporary service, contractual service.
Considering our affidavit regarding.
Take into account.
How like that?
You have not filed affidavit, what to do?
Yeah, filer.
Huh?
Yeah, filer.
You have filed, okay.
They have
Very
also filed
good.
their.
Yes.
Lordship, sometime may be given to us to file the reply in regards to affidavit in opposition filed by respondent number 2.
Marat, we are saying an profession Marat regarding interim order. How interim order they got it? Lordship, can they see?
What interim order?
Marat, we data is related to de-affiliation of the schools. Because Lordship, can they see? Interim order, Lordship, can they? 27/5/2026. Hard so and so by application filed at yeah. They have paid for passing of the increase of the 50/5. The case of the petitioner is that there was a leakage of mathematics paper in connection with the high school the 1st of March 5. And a FIR was lodged in regard to the sale on 25 and investigation is on. In the meantime, so for notice was issued the school concern and a reply was also submitted. The entry to the it is stated that the person involved in the decrease of mathematics paper is one of the owner of the same school. The same fact was also stated by the principal of the school during the hearing conducted to the secretary Assam. Okay. Considering the fact and circumstances of the case, also need to fact that the investigation is at the nascent stage, and for the benefit of the student, this would give it that the impute order dated 12/15/2025 be state with the next step. So, for misleading this honorable court, my lord, has obtained this interim order. So, can you see our affidavit? For a moment, my lord.
Your affidavit?
Yes. In our affidavit, my lord, data has page 61. 3rd of October 2025. This is the report of the CID officer that inquiry. CID officer submitted report on 3rd of October 2025. Inquiry completed and investigation and after completion of this thing, submitted findings, key findings of the investigation. So petitioner submitted it in nascent stage because it is pending investigation. That's why honorable court was influenced by him to pass an interim order. That's why, Madam, I have come.
No, no. What is the allegation?
Allegation, Madam, in 2025, Madam, mathematics papers and other papers were leaked in the said school. And Madam, what happened? The petitioner, the head principal, son of the principal, owner, the son of the principal, he himself, Madam, involved in the Madam, page, peruse the 61 page last paragraph. There, so that's why, Madam, after investigation received by the CID, from the CID, the board issued so cause notice, and he was given an opportunity for hearing. And after he submitting it, Madam, the de-affiliation order has been passed.
Now, what will be the effect of de-affiliation?
De-affiliation means because the school is affiliated for to admit the students class 11, class 12 like that. Then we have de-affiliated because this center is the main center and the owner of the son. He himself not involved in the leakage of the paper. That's each hamper. For that purpose, we have to postpone the examination twice. Once the examination is scheduled
that if it is conducted, it involves so many persons, district administration, teachers, and others also, man. So,
No, we
it
have
hampers us.
understood.
So, interim should not be continued. And also, we passed the page 68, my lord. The board has taken care of the students. He says the board students will be affected. Page 68. The order of this, my lord, our secretary, the impute order. The students of the class 12 for whom the form fill-up process has already been completed by the institution, they continue their studies in the institution until the commencement for higher secondary final examination. We have taken care of the students, those who have already been form fill-up, who already submitted form for the SSLC examination 2026. So how student will be suffered for? Blessing before this one, honorable court on that day, for stage, but the petitioner misleading all these things. But this interim order was passed. And paragraph 60 of page 64 also kindly see, the secretary issued notice to the principal, this institution. With reference to above, I hereby advise you to physically present and secure that as mentioned below for hearing and recording statement. You are requested to attend personally with records like copy of the order of permission, affiliation, result of the 3 years, details management, office seal and writing. So accordingly, he appeared, madam. Page 65. His written statement. Principal's written statement is recorded in page 65. Resignation principal, Gauhati Advanced Academy. I am holding the charge of principal since August 25. At the time of incident, principal was Atiful Hussain. He resigned from the service. I do not know detail about the incident as I joined in the institute on August 25. I signed the reply of the so-called notice as I was stated and advised by the president and vice president of the managing committee. The owner of the school is Nasiruddin Muhammad Achik, is son of the Nasiruddin. That is the manner I heard the Achik was arrested by the police at this incident. The owner of the school is son involved in the
Under what rules do you follow? What are the rules under which?
What rules?
Show us the rules.
So I am on at present, Manoj, regarding interim order. But misleading this.
What is the misleading aspect?
That is why he says that investigation is pending. Investigation is going on. In fact, Manoj, October 2023 investigation has completed. And accordingly, we have issued so-called notice to the principal and requested to appear. 11, Manoj. Withdrawal and recognition and affiliation. The privilege of the recognition may be withdrawn and withheld of any for any period from any institution by the authority competent to recognize this institution.
Against this, there is no appellate provision.
The appellate provision is affiliation, yes. The board shall issue orders of recognition, affiliation, new government and provisional school. It is not there. So board has power to de-affiliation of the.
No, we understand you have power. Now you have said that these students of class 12 will continue.
Oh yes, we have given.
Now, will they be permitted to appear from their institution? No.
Scale, no. More new candidate student can be admitted for class 11.
That is all right.
Yes, for class 12, at the time of incident, they are allowed to continue and they will appear in the examination.
They will appear from that school only.
That school also, because these students also, those school, class 12, then we have taken care that they will not lose anything. So, interim order is not necessary because he is misleading this court. The investigation is pending. What investigation is pending? Before 1 year, investigation of what is CIT has submitted report. They and
are you going for new admissions?
Lordship, as I have prayed for them, I need some time to file the reply.
No. You see, you have been de-affiliated.
Yes, Lordship.
Now this order is under stay. So far as the students of class 12, they should not be disturbed.
Yes.
But in view of the cloud regarding the reputation of the school, are you contemplating to go for fresh admissions?
No, 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 Lordship. Lordship.
This is my lord, my son, my submission is there, my lord. Let them file, my lord, reply, no problem, but interim said not to continue.
Lordship, my
In the main
senior,
case, we get, idea occasion was to seven occasion. Seven occasion, he, my lord, dealing the tactics.
Who is your senior?
Lordship, Mr. K. Borwa. I just not so much.
Where is he? Where is Mr. Borwa?
Lordship is not in the court, Lordship.
Idea, faster when he moved in without serving our copy, my lord. Without serving our copy, informing us, he moved this petition. And said that prosecution is pending.
Did you file an application vacating the stay? No.
No, we can file it, but
No, we are not inviting you to file. We are asking you, did you file? You did not file.
No, but we have already filed an affidavit. We are
Filed an affidavit, Mr. Counsel, you know how the system works.
So, Malad,
If you are aggrieved by the stay order, getting an ex parte stay without serving copies, you should have filed an application.
We have filed a affidavit on 26 July 2026.
Very well.
Till today, they have not filed any reply.
Very well.
And Lordship, kindly see our affidavit page 56, the order of the school, 24th June 2026. Heard along London Council petitioner, the State Council submitted. Present revision will file asserting an order passed by the board authority. However, the petitioner had not served a copy of the petition to the London State Council of the board prior to filing of the same. He submits that the order dated 27 May 2026 was passed by the court without hearing the board. Mr. Shukya Lanaka so
the heard counsel, party counsel for the petitioner, the prayer for filing the rejoinder affidavit. It is a prayer for filing the rejoinder affidavit. Please for staying. So, Mr. T.C. Sutia, Senior Counsel, assisted by Mr. D.K. Roy, appearing for the board, Assam State School Education Board, submits that while there is no objection for grant of time for filing the rejoinder affidavit, the interim order passed on 27/5/2026 may not be extended. The petitioner is agreed by the order whereby the school on the ground of on the ground of their reply being found to be unsatisfactory by the ASSEB authorities in respect of leakage of question papers relating to higher secondary first year examination to be held on. It was scheduled to be held on 21st of March 2025 from that school and some other schools. So, because of the leakage, the examination was scheduled and the question papers were issued. Stop. Upon the inquiry, on the basis of the information available, an FIR has been lodged, where the CID has filed, where the CID has undertaken the investigation. And the son of the owner of the school suspected to be involved in the leakage of the question paper has been arrested, apprehended by the CID. Consideration of the reply by the school submitted to the show cause notice issued and upon consideration of the upon a personal hearing in consideration of all records, that institution had opened the seal of the question papers of the first year higher secondary examination 2025 before the scheduled date, violation of the examination norms, which of the sanctity of the examination process. The son of the owner of the institution was apprehended to begin the question paper, subject to mathematics. Such circumstances, the board has ordered for permanently de-affiliating the school from the so-and-so board division to immediate effect. Students of class 12 for whom the form fill-up process has already been completed by the institution were, however, permitted to continue their studies in the institution until commencement of the higher secondary final examination 2026. So, while issuing notice, this court by order dated 27/5/2026 stayed the order, impugn order, to the next returnable date.
Can you see, one of the alia order 24 to 26, page 57. 57 says, further continuation of the interim order would be considered after hearing teacher study council, hearing board, or a next day district. That's why we did not prefer money IA for vacating the interim order. That's why we have filed an affidavit.
So what is the apprehension expressed by the board that they will that the benefit they will get by the interim order?
Interim order means different, they may come with the contemplation because they are not stopping it. We have de-affiliated. But de-affiliation we have not done, we have done. Again, there is stay order. If stay order is there, so we should follow the stay order because we restore the early order. That they may come with a contempt.
We are asking you, how are they benefited by the stay of this order? I mean, what steps have they taken?
Yes. By stay order, they will be able to get admission in the class 11.
That's the only apprehension.
Apprehension, that is fine. What may modify it?
The submissions made, prayer issue, matter listed. How much time you want?
Lordship, at any short date, I will just know.
You tell me how much time you want to find your reply.
For 2 weeks.
2 weeks time is prayed for. The matter be listed on 28th. 26th of August. The question for extension of the interim order will be considered on the next date. After filing of the reply affidavit as prayed for. Meanwhile, the petitioner is not permitted, will not proceed for fresh admissions in class 11.
11.
Only class 11.
11.
Not in 12.
We're already there. We are allowed them. And
is there a scope for fresh admission in class 12?
Yes, 11, not 12.
No, class 11 for the session 26-27.
Yeah.
Without leave of the court.
Give the obligation.
Yes.
But here I had filed an IA, Lordship, for implement of UGC. Inadvertently, I have left out that while.
Any objection? Third counsel for the parties. IA has been filed by the petitioner seeking implement of GC, which the petitioner submits. This is the department, but the website is able to only. It's not read as a party. The company, the case is so and so. The petitioner has approached his court. Seeking a direction to the Cotton University authorities permit her to secure admission to PhD course in the Department of Assamese. Stop. Petitioner was not selected despite the petitioner being under PWD category. According to the petitioner, there are 8 seats for PhD at the Department of Assamese in Cotton University. And as per the reservation policy, 5% must be reserved under the for the PWD category. Under this
Rights
right
rights of persons with disability.
right of persons with
2016.
disability. 16 Act reservation for 5% the candidates required, which the university authority. Such circumstances, it's fine. C has also issued guidelines and indications from time to time in this regard. C is the necessary party. Without erring which the relief claim for the highest is allowed. UGC the rate as party respondent number 5.
Yes, Lordship.
WTC number so and so. Since the UGC will get opportunities to file their objections or affidavit petition after the highest stands allowed, they are issuing notice at this stage. Petitioner will file amended course title within 1 week. Disposed the petition in view of the order passed today in IA number so and so. UGC is arrayed as a party respondent and as a respondent number 5.
Yes, Lord.
Petitioner will file amended course title registry within 1 week. And extra copies be furnished to the standing counsel if available, failing which the petitioner we issue notice after it comes. After you file
Yes, yes, Lordship, I'll file it.
matter be listed immediately after 1.
Petitioner
E.
Petitioner is
E.
And Lordship, I'm as a legal aid counsel.
MSD Ghosh appears as the legal aid counsel.
The-
Mr. P. Dyer, senior counsel, assisted by Mr. Rahman, appears for the Cotton University, Mr. Rehia, for higher education.
deep here.
Deep.
Government was supposed to be filed the affidavit in opposition.
The matter is pending in the apex now, apex court now. So, and next date is fixed on 14/8/2026. So, this 10 days may be granted, madam.
What is the issue here?
Yeah, madam, they are seeking provincialization under 2011 Act. Madam.
They are what teachers? But there are so many orders which have been passed by the apex court recently.
Yes, and now one SLP, my lord, 29771/2024 is pending, my lord. And it is next date is fixed on 14/8/2026.
It is submitted that similar issues are pending before the apex court. In SLP number
29771/2024.
9771 of 20, submitted by the State Council. The matter is fixed on
14/8/2026.
2026. Therefore, submits that the petition be listed after para. The submissions of the council is not objected to by the council for the petitioner. This matter again after 2 weeks. The State Council will place a copy of the order that may have been passed by the Apex Court on 14/8/2026. Released after 2 weeks.
Here I am saying for recommendation to complete the instruction lodging.
Right?
Elementary.
Elementary education. Yes, madam.
No affidavit is filed in this.
No affidavit. Why no affidavit?
Instruction is awaited lodging.
2024 matter.
What is your claim?
My lord, for pension and area salary. Petitioners were initially appointed as stipend teacher, my lord.
SP Burman appears for the petitioner. The response counsel appearing. The respondent submits that instructions are not received. She prays for 2 weeks' time. 3 weeks' time.
A date will
It seems that several opportunities are granted to the respondent to file their affidavit. However, the affidavit has not yet been filed. Accordingly, the matter be listed on 11th of September, by which date the respondents are expected to file, are permitted to file their rejoinder affidavit in opposition. Released on 11th.
as the last
September.
sons, my lord.
Huh?
As the last sons.
You renew your prayer on 11th, they don't file.
Much of.
In last occasion, the council from education department was asked to obtain instruction on the speaking order on the basis of which report the speaking order was passed. The report
Yes.
is not.
This is awaited lordship.
Why is it awaited?
Lordship, earlier date it was someone other was appeared before this honorable court.
That is not our fault.
No lordship, today also someone other is attached with the matter.
Who is entrusted?
Aruna Fupon, F. Fupon.
Where is he?
Is not here lordship.
So why are you entrusted the matter to somebody who's not in court? Who entrusts these matters? Who's your senior standing counsel? Elementary education?
SMP 60 annotated the matter.
Please call him. Is he here?
I don't know.
Call him.
Is that on every occasion?
We are listing this matter on Wednesday. Please inform him that he has to appear in the matter. On the last occasion, on the last date, the matter, the opportunity was granted to the standing counsel, the elementary education department, submit the report or communication of the DEO Morigaon, which was stated to be relied upon by the Director Elementary Education while passing the impugned order, rejecting the grant of child care leave application of the writ petition. Application was rejected.
Yes, sir.
That today, and the matter is fixed today. Today, when the matter is called up, the MSSO submits that the instructions are awaited accordingly, and also that some other counsel is entrusted with the brief. Considering submissions made, request Mr. SMT Chisti stated to be the senior standing counsel.
Deposits were here lordship.
And
AG. And but our education matters were allotted by SMT.
request Mr. SMT Chisti. He's for elementary.
Lordship.
It's the council for what do you call your secretariat? Department of School Education. The standing counsel for Department of School Education to appear in this matter for assisting report. Copy of this order we mark to Mr. SMT Chisti and his name will be reflected in the post list by the registry. Based on, we'll have it on Friday. 14th. 14th.
My name is also not reflected, so there is a chance
Council's
of
petitioner's name is also be required to be reflected in the post list.
that is it.
Yes, that is it. On 14th.
Okay. Obliged.
Yes, Mr. Chaudhary,
Yes, my lord.
what is the matter?
Matter is relating to my lord. I obtained PhD degree from the Gauhati University, my lord. And my lord, they are not considered my degree, my lord. And that is why I was appointed as a Shiksha Mitra, my lord, in 2015. I challenged this order, my lord. And when I challenged this order, my lord, they filed an affidavit stating that they have a committee has been constituted and they are, my lord, doubt about genuinity of the degree, my lord. My humble submission before your lordship is that, my lord, I was appointed in the year 1999. 2011, my lord, I joined PhD, my lord, and subsequently in 2013, I got the PhD degree. That is the case, my lord.
From Mogad.
Mogad University, my lord. I am coming, my lord. One thing, my lord. Most important thing is that, my lord. Lordship, kindly come to the, my lord, my petition, my lord.
The UGC is not carried in the party.
Yes, my lord.
Not carried.
Yes, my lord. May I, my lord, do one thing, my lord? I shall
UGC
is
is
a necessary party, my lord. I shall file an imprisonment petition, my lord.
The question present proceeding validity of the PhD degree.
PhD degree.
Obtained by the stated to have been obtained by the petitioner from Mogad University.
Yes, ma'am.
Each of the respondents have questioned the validity of the degree. Huh? Acceptability of the degree.
In affidavit, they have learned genuinity of the degree.
Genuineness of the degree.
They have like right down in the affidavit in opposition.
All right. Acceptability, genuineness,
Generally, any
validity
word
of the
was
degree. According to the court, the presence of the UGC council will be necessary. However, UGC has not been carried as the party. Council with the petitioner therefore submits that we would like to take steps where UGC is the party response. We are made the list after 1 week.
Yes, ma'am. Well, can be 2 weeks, my lord.
2 weeks. Yes.
My lord, the respondents are about to file an affidavit.
Affidavit.
We have already filed affidavit on one thing, my lord. Last occasion, lordship directed us to, we have said his birth certificate 2025 is tempered. Lordship asks us to verify from the competent authority. We verified from the competent authority, but Joint Director of Health Service, but and that.
Have you brought this on record?
Not record.
Huh?
We have already filed affidavit. We will file another.
File it, bring it on record, give them an opportunity to rebut. deference to the earlier order dated 14/7/2026, the board authorities steps to verify the birth certificate bearing registration number 3969 dated 12/5/2005 have stated to have been issued by the Health Department and place the views of the Health Department regarding the veracity and genuineness of the documents. Thereafter, the authority thereafter took up the matter with the Health Department and the standing council, the council representing the state, Assam State School Education Board Division 1 has placed before the court a communication dated 21/7/2026 issued by the Joint Director Health Services which reflects that which states that which reveals that as per official report, the Health Department has informed that the certificate is not issued by the office concerned Health Department. So the council for the respondent is permitted to bring this document of the court by filing additional pleas. Steps be taken within 2 weeks.